was permitted to operate and function without the requisite permissions required to be taken by the owners, managers, handlers of the TRP game zone in Rajkot under the provisions of the Gujarat Provincial Municipal Corporation Act 1949 and the Gujarat Fire Prevention and Life Safety Measures Act 2013 and rules and regulations framed thereunder, and in breach of the directions issued by the Honourable Supreme Court of India at Annexure 3 and also the directions issued by this Honourable Court at Annexure 2 collectively. I'll take my lords to this later. Issue appropriate directions as may be found necessary against the persons accountable for public accountability, including the officer of the opener number 8, that is Rajkot Municipal Corporation, and such other persons in service of the state of Gujarat and or the opener number 8, who may be found responsible for the loss of 24, it may have increased now, lives and the non-compliance of the directions issued by the Honourable Supreme Court and this Honourable Court in exercise of prerogative powers under Article 215 of the Constitution of India. D. All the opponents herein and more particularly open number 1 and 8. 1 because 1 has always been a party from the very first day when the notice was issued. Affidavits have been filed and directions have been issued in these proceedings where, including the Supreme Court, where the opponent number 1 is also a party. Opponent 1 and 8 herein accountable and guilty of non-compliance with the directions issued by this Honourable Supreme Court of India at Annexure 3 and also the non-compliance with directions issued by this Honourable Court at Annexure 2 collectively, which has resulted in the loss of 24 human lives, and issued directions to concerned opponents to recover such amount of compensation and penalty as may be found from the erring person and direct the same to be recovered and deposited in the registry of this Honourable Court. But usually what happens is compensation is paid from the state, it is taxpayers' money. I'm sorry. Direct the registry of this to place papers, which of course would be there. Now, my lords, if my lords kindly see, under the provisions of the Gujarat Provincial Municipal Corporation Act, under the Town Planning Act, general development regulations are framed. So, my lord may kindly have a look at the GDCR. First, my lord, part 1. GDCR. The regulation.
Mr. Panchat.
Yes.
We may be a bit handicapped as a result of the
No,
masters.
No, that's all right. I understand. But I will try and assist as much as possible. Yeah. I'll give my my lord, may pardon me, 1 copy.
Because like the
Achha, he's got. Very good.
special bench, even here the staff is.
There's special staff also with a special bench. No problem.
Huh.
Yes. No.
You want to have this copy?
I may, then if it's convenient, I
Yes,
may
yes.
take 1 set. So that if I have, yeah, maybe apart. No, no, in the first part. Thank you, Kaushal.
But I have a second.
Welcome back.
I just the second copy. I have the second copy.
Very good.
Professor.
Achha. Those are 2 sets. Yeah. Not regulation 3 in part 1. Probably the page is 32. Probably. No, these are the regulations framed by the state of Gujarat. My lords.
Development permission required.
My lords, my lords. Okay, page 32 છે page 32 છે હા આપો May I read, my lords? This is regulation 3 of the GDCR, and my lords, pardon me, kindly go to the first page. These are regulation. The first page, this is 3/10/2019, first page of this compilation. Let me just read. After the Government of Gujarat Urban Development so and so, Sachivalaya notification 3/10/2019. My lord, Justice Desai has got here. Number so and so, whereas the Government of Gujarat is of the opinion that it is necessary in the public interest to make variations in the comprehensive general development control regulations notified with a notification number so and so dated 5th September 5th November 2018. Hereinafter referred to as CGDCR by the Urban Development number so and so Gandhinagar. Thereafter, my lord, published certain notifications, etc. Suggestions are in. Now kindly see. Now therefore, whereas as considered, and then the fourth. Now therefore, in exercise of the powers conferred by subsection 2 of sections 116A of the Town Planning and Urban Development Act 1976, section 155 of the Municipalities Act, clause A of section 31 of the Gandhinam so and so, government varies after the various hereby sanction the said variation with modification. So these are, my lord, statutory binding under the official, my lord, by the state. Now come to section regulation 3 on page 32. Development permission and building use permission. Development permission required. Subject to the provisions of the relevant sections of the Town Planning and Urban Development Act or so and so, any person, this is what I would lay emphasis on, any person can carry out any development in any building or in or over any land only after making an application in writing to the competent authority. So there is a prerequisite to use of building or land. In the present case, my lords, this land, if I may use the word, of about 3,000 meters, square meters. As far as I am concerned, to my information, no permission has been applied for use of this land. This is under regulation 3, no application is made. This is my first submission. Kindly come to page 93 of this compilation, schedule 10. Page 93, schedule 10, and this is list of building specifications verified. Page 93, my lords. My lord, schedule 10. My lords have the first volume. Building regular, probably my lord, schedule 10. So, yes, I'm sorry.
Same page, page 90.
Yes. Schedule 10, list of building specifications verified by the competent authority before issue of building use permit. So this is a kind of a checklist. And this is, if my lord see the first line, refer regulation number 3.9.1. And I may read, before issuing building use permission, competent authority shall check that. Now kindly, I may, number 2, parking space is properly paved and layout of parking space is provided as per approved plans. Signboard indicating entrance, exit is relevant in this purpose, and location of parking spaces for different types of vehicles shall be permanently erected and maintained at the prominent place in every building unit. Kindly come to number 4. Therein, proper arrangements are made for regular maintenance of fire protection services as provided in NBC. NBC is National Building Code. This is, for a moment I may say, National Building Code Part 4 deals with fire safety. So there is no ambiguity here that this is required to be provided as per the National Building Code of India, Part 4. I mean, Part 4 that's the only chapter. So fire safety or protection services have to be there. Then, my lords, number 6. the concerned authority issuing occupancy certificate, before doing so, shall consult the designated authority. Not in the present case, if it is within the corporation limits, it would be Rajkot Municipal Corporation. Other, if it is outside, it would be the Urban Development Authority. The concerned authority be issuing occupancy certificate before doing so shall consult concerned designated authority to inspect the building and issue a certificate that necessary requirements for fire protection under the provisions of the Gujarat Fire Prevention and Life Safety Measures Act 2013 and rules and regulations made thereunder, and any other environmental provisions like that of waste so and so, and criteria for accessibility to the building like ramp, accessible parking, accessible toilet for disabled persons have been fulfilled.
Building is defined anyway.
Sorry?
Building is defined anyway.
Yes, I am coming to that definition in a minute. I'll take my notes. Thereafter, my lord may turn to the next page. Building, if I may say, there are lots of buildings in this. As far as
Temporary structure is not a building according to.
no, I'm saying it would fall within a building. Even that would fall.
Suppose, let us.
No, it falls. Somebody may say that there is some confusion, but my lord, anyway, that's a question of my lord's
I
interpretation.
will address the Honourable Court on this.
Yes. That is
But
why-
she may address if she wants to do it now. I will because
I think if my lord can hear me, though I am generally in serial number 2.
We kindly wait.
I'm not defending it.
No,
This confusion will be over in 1 minute.
Yes.
Our stand is very clear.
but I will try and be as clear. Maybe not as clear as my
It's
learned.
not adversarial, sir.
Then I agree, but I'm saying
Hear me out before.
next page, my lord, page 94. Schedule 11.
Nobody is adversarial to anything.
Yes, not my learned friend. Schedule 11. Building requiring fire protection consultant and inspection by chief fire officer. Now, this also refers to the next line, refer regulation of 3.9.1, etc., etc. So, this is also mandatory that you should have a fire protection consultant, and after the report or whatever they make an application, inspection has to be carried out by the chief fire officer. Why I am saying this is, as per my information, and which I have said on affidavit, there is no permission from the department as regards fire safety. And my lords, there is no application made under the GDCR, Corporations Act, for use, development and occupancy of this area by the owners, managers, handlers, etc. So in my respectful submission, this has been done without any valid legal permission. Let's kindly come to page 57. Yes. This is while it is being constructed because a report suggested. I also have page 57. Page 57. This is procedure during construction. Well, it has been reported because after the government says that it was under construction or whatever, or the corporation. So procedure during construction is what the regulations indicate. Kindly come to, this is with regard to inspection, etc. But number 5.1.3 in 5.1, Lordship may see inspection, my lords have 5.1.3. That is just to
Documents and drawing.
no inspection 5.1.3
Inspection of fire.
for fire safety and protection of building under construction. For building listed in Schedule 11, but I'm focusing more on fire safety because of the fire. Otherwise, there are a lot of other things. For building listed in Schedule 11, which my lord just saw, page 94, the Chief Fire Officer shall carry out inspections at appropriate intervals to ensure that the fire protection requirements and measures for such building under construction are adequate and operational. No, operational is more important. The Chief Fire Officer shall also satisfy himself that all elevators, including fire lifts, and are duly tested and their test certificates submitted to this true satisfaction. If the above work is entrusted to a registered fire protection consultant on record, his report shall be countersigned by the Chief Fire Officer in case of inadequacy, etc. So, my lords, this has not been done. I may request my lords now to come to part 2. There are 3 parts. In this part 2, to just point out the category. Part 2. Part 2, my lords may come to the table 6.3 on page 10.
Part 2 is part of this. In this, it will be like what I handed over to her.
Oh, this is easier.
Okay.
My lords have page 10. My lords.
Yes.
This is table 6.3. Which indicates use permitted in each category. My lords have kindly come to number 5. Number 5. Number 5 is mercantile 2. This is on my gathering information. Mercantile 2 is the type of building in which the municipal corporation of the city of Ahmedabad gives permission. Because gaming, etc., is not defined in the Act or under the GDCR. But because Mercantile 2 suggests a shopping mall to start with, M2. First thing is, in category M2, kindly see the uses. The first use is shopping mall, then laboratory, etc. So, since there is no specific clear definition of gaming under the M2 category, use is permitted. And that is what in Ahmedabad Corporation, at least this is what subject to what the Rajkot Corporation Council has got to say. So this is under which the permission is, use is permitted. There, my lords, one more aspect. In part 3, just general, part 3, page 20. Page 20. This is number 14, fire prevention and safety. Page 14, chapter 14, page 20. Fire prevention and safety. Fire prevention and life safety measures shall be as per provisions as per fire prevention and life safety regulations. So and so amended from. There is a complete law with regard to Gujarat Fire Prevention and Life Safety Measures Act 2013. Thereafter, rules are framed and regulations are framed by the state of Gujarat, which are binding and which are applicable today. So under this, they have to comply. So my respectful submission is, no application has been made with regard to even this fire prevention and safety with regard to this area structure, whether temporary or for permanent use or for regular use. Therefore, my lords, my respectful submissions, provisions of the Town Planning Act with regard to comprehensive general development control regulations have not been complied with. Number one. Neither have the regulations, rather the provisions of the Act, regulation and rules with regard to Gujarat Fire Safety, Fire Prevention and Life Safety Measures Act 2013 been followed or complied with in any manner whatsoever. In fact, my lord, I came across reports which said that the Chief Fire Officer Rajkot made a statement there is no application received by them. And not an NOC will come subsequent to an application being. First, you have to install the fire prevention and life safety measures as required, the schedule under 11, which I pointed out. Thereafter, my lords, they have to be inspected. After maybe a fire protection consultant may give that this is what we have provided. And then, my lords, the fire NOC is issued by the competent authority. These days, my lord, or rather lately, fire NOC is granted not by the fire brigade department, but the state has amended the rules, and now they are appointing fire safety officers who inspect because of probably workload, and they give a certificate. But in the present case, nothing of this kind has happened since there is no application made. Then, my lords, one more aspect, the general aspect of permission under the GPMC, Gujarat Provincial Municipal Corporation Act, chapter 15, sections 253. Yes. Then GPMC. Minus. Page 177, possibly. To 269. That's 253 to 269. This is the chapter under the Gujarat Provincial Municipal Corporation Act, which deals with building regulations. In this, to start with section 253 may be seen. This is because somebody may say that, well, since it's the corporation limits, we may apply only under this. But even this has not been done. Therefore, 253, chapter 15, GPMC Act, building regulations. Notices regarding erection, etc. of buildings. Notice to be given to Commissioner of intention to erect building. Every person who shall intend to erect a building shall give to the Commissioner notice of his intention, said intention, in the form prescribed in the bylaws and containing all such information as may be required to be furnished under the bylaws. Then 2, every such notice, etc. So this is a procedure prescribed, my lord. Building is defined, my lords ask, my lord, building is defined. In the Corporation Act, it is, take my lord, section 2. Number 5, numerical 5. Building includes, my lord, sir. Building includes a house, outhouse, stable, shed, hut, and other enclosure or structure, whether of masonry, bricks, wood, mud, metal, or any other material whatsoever, whether used as a human dwelling or otherwise, and also includes verandas, fixed platforms, planes, doorsteps, walls, including compound walls, and fencing and the like. So under the Corporation Act, this is. Now, under the GDCR, building is also defined. If I may just for a moment take my lord, I'm sorry. So the first,
2.12.
my lord, I'm obliged. That is internal page 6. It goes up to J. So building, hello sir, may I read? A building means all types of permanent building defined in A to J below, but structure of temporary nature like tents, hutments, as well as shamiyanas erected for temporary purposes or ceremonial occasion with the permission of the competent authority. I'm not. This also includes, interestingly, unsafe buildings. The last one, 2J, even and hazardous is also there. First, my lord, may I have a look at 2J, unsafe building. Means a building which is structurally unsafe, is sanitary, is not provided the adequate means of egress. But I was told that there was only one entrance and exit in this area or this place where the unfortunate calamity took place. Constitutes a fire hazard. This very definition is dangerous to human life. In relation to its existing use, constitutes a hazard to safety of health or public welfare by reasons, etc. So, my lord, and my lord, just before that, kindly come to G, 2G.
Page.
Page 6, 2G at the bottom. My lord, hazardous building. Means a building or a part thereof used for storage. I was told storage is also there. Handling, manufacture or processing of radioactive or highly combustible or explosive materials. Second line. Or products which are liable to burn with extreme rapidity and or producing poisonous fumes or explosives, inhabit tubes, then storage, handling, etc., which includes storage. So this, I don't think there's any dispute on the fact that there is no permission taken from the competent authority. It falls within the definition of building.
We have not heard.
No, this is my the other side may.
250.
And now, my lords, my lords, may kindly come to page 251 to start with.
51.
Yes, of the paper, the orders passed by the Honourable High Court.
The order of 15, 12, 22.
My lords, I'm obliged. This is, of course, the second order. This 15, 12 is the first order. This is 26-2.
This
What I was referring to. The order which it starts at 186, slightly longish and exhaustive order. Page 186 is the order dated 26/2/2021 in this public interest litigation. Page 186. Lord said, page 186 of the paper.
is 26 to 20.
My lord, yes. Now I may read the very first paragraph. Pursuant to the order passed by the Honourable Division Bench, pursuant to the order passed by this court dated 15th December 2020. First paragraph. It refers to the earlier order. More particular directions contained so and so and so. The state government has filed additional affidavit, and then, my lord, it refers to various provisions. My lords may come to page 250. Paragraph 23.
250 is part of the 15, 12, 2020.
No, my lords, this is 26-2.
Page 222.
Which page 2? Yes, my lords are referring to.
You are referring to page 250.
Yes, just one minute. My lords
The
are.
order begins at page 222 somewhere.
I'm sorry, yes, 15-12. I stand correct. I stand correct. I'm sorry.
Yes, no.
Slightly early in the morning. Page 250. Paragraph 23.
Page
250, paragraph 23. This order, 1512 order.
after due consideration.
Yes, this is what the Honourable Court, after considering what is stated above,
This is
after-
in connection with hospitals.
also. After, this was actually filed, civil application when the Trey Hospital took place, etc. 23. After due consideration of all the relevant aspects of the matter, we deem fit to issue the following directions. Number 1. The respondents are directed to forthwith ensure that the fire prevention and life safety measures are taken and implementing forthwith with the FPPS, Fire Prevention and Protection Systems, installed in all the buildings in the state of Gujarat as required under the GDCR 2017, which my lord just saw, which are in force today. The respondents are directed to ensure that all the buildings in the state of Gujarat have the adequate disaster management infrastructure and proper firefighting and rescue equipments as required in the National Building Code of India. Now, National Building Code of India is part of the main matter at Annexure H and also is required by the Standing Fire Advisory Council, Ministry of Home Affairs, Government of India. So this is a specific direction with regard to two things. Then number 3, the respondents are directed to ensure that effective steps are taken forthwith for the fire prevention and safety, for the protection of the life and property of citizens in various types of buildings and temporary structures in the state of Gujarat, so as to serve the object and purpose of the Gujarat Fire Prevention and Life Safety Measures Act 2013 and the rules and regulations framed there. So specific directions, 1, 2 and 3, my lords have seen. Then what is the, if after they following the provisions, kindly see number 4. The respondents are directed to grant occupancy certificate to the applicant occupant of the buildings in the state of Gujarat and permit occupation of the building concerned only after consulting the concerned designated authority which issues the certificate after requisite inspection of the building, so as to ensure that necessary requirements for the fire protection have been fulfilled as required under the provisions of the Gujarat Fire Prevention and Life Safety Measures Act 2013 and the rules and regulations there, and no objection certificate NOC from the concerned fire department authority has been produced before the competent authority which issues BU, Building Use Permission, Occupancy Certificate in conformity with this Comprehensive General Government Regulation 2017. Now, my lords, kindly come to number 13 on page 254, direction number 13.
What?
Number 13, paragraph 13, page 254. The respondents are directed to act strictly in conformity with the provisions of the Gujarat Fire Prevention and Life Safety Measures Act 2013 and the rules and regulations framed thereunder, the National Building Code at Annexure 4, and also as required by the so-and-so and CDGCR, while taking any administrative steps and or action, more particularly chapter 5 of so-and-so prevention, fire prevention. No? Then, my lords, what happens if the direction which have been issued?
Read para 24 at page 256.
I'm there on that, page 24, paragraph 24, page 256. Subject to what the respondents have to say with regard to fixing the accountability, we propose to fix the accountability as under occupation without BU permission, the owner, builder and developer is responsible. Expired NOC, no NOC, occupant, owner, chief fire officer. Number 3, accountability for illegal action or inaction by the authority, municipal commissioner, deputy municipal commissioner, estate department, deputy municipal commissioner in charge of the concerned department, chief fire officer. Then, my lords, what is that? Kindly come to just one more paragraph in this. 57, paragraph 26 and 27. On paragraph 27, as observed by the Supreme Court almost 2 decades back, that the governor runs the executive government of the state and with the aid and advice of chief minister and the council of ministers, which exercise powers and performs his duties. Paragraph 27. This is just general observation. What they are trying to say is that they are accountable and answerable to the people. Here, 24 to 28, depending on the exact number of persons who have passed away, children and adults. My respectful submission, my lord, this is nothing short of murder. While they have said 304, part B or A, whatever, that it doesn't amount to murder. My lord, there are statutory provisions which they are required to comply with. Not only the applicants, not only the users, not only the owners, but the authorities are given responsibility under the statute, which they are supposed to administer, follow, and implement. Subject to what the respondents have to say, the state as well as the municipal corporation, in the present case in Rajkot, if application has not been made as required under the provisions which I just pointed out, what action has been taken? How did the property get occupied, used? And my lords, there is all.
How long is this game zone was working? Yeah, in use?
My information about
18 months.
2 years.
18 months.
18.
More than 18 months.
And my lords, also, if I may be permitted to refer to the news report today. My lord, while this had been opened, my lord, the municipal commissioner, the collector, the police authorities. So what I'm trying to, I'm not objecting to that. It's their choice. They may go wherever they choose. But the very fact that this is within their knowledge, this establishes knowledge of the authorities that such a thing exists. Maybe it was inaugurated, but it exists. And all the authorities, the collector,
The commissioner subsequently have changed.
yes, all the officers possibly, maybe 1 or 2 men, but that is not the point in issue. I'm not trying to make it a personal issue or
Not by name.
not by name, but definitely, I may even forget they're going there. Is the corporation, is the police department, is the fire department, is the collector not aware that such a large property is being utilized by so many persons and has been utilized, unfortunately, till this event, unfortunately. So, my lord, now paragraph 29, before I take my notes to the Supreme Court. Page 259, paragraph 29. We may only say, while closing this order, that the mode and manner in which the state government is fighting a gallant battle against the COVID, because this was a COVID time, by implement so and so to protect the subject. We expect, last line, we expect the state government to take this issue of fire once and for all with all seriousness. The COVID-19 will surely perish one day, but the problem of fire will remain for all times to come unless adequate and appropriate steps are taken in the right direction. Then confidence is reposed, and court says that we could extend a help. So these are the directions which are binding on the respondent authorities, which are parties to this proceedings since 2020. Well, the original proceedings started in 1997, where directions have been issued. by the Honourable Division Bench, Special Civil Applicant 4578 of 1997, which have been quoted in this. They are also binding. Various division benches, Honourable Division benches have quoted and referred to those proceedings. And that these should be followed. Because they, had you taken some step, in fact, the irony is, though directions were issued in 1997 for the first time, the Fire Act or Prevention Safety Measures Act came only in 2013. Rules were notified only after 1 year, 2014. And thereafter, my lord, this is the unfortunate. So, while the Honourable Court has expressed its hope, nothing further has been done. Now, the Act is there, the regulations are there, the rules are there. Why are they not implementing them? There is certainly, my lord, an accountability. People are dying. And, my lord, kindly take judicial notice of the fact. My lord, Bharuch fire, Rajkot fire, Surat fire, Ahmedabad fire, hospitals fire. How many more fires do we require for the government to awaken, for the authority to get up? And my lord, they charge everything. They charge for everything officially, if I may say so.
Yes.
So, my lord, 280, Annexure 3.
That's all.
Sorry.
That's all.
No, I have just begun. Page 280. No.
Just begun me.
The reason is, my lord, civil applicant, my lord will take cognizance because I am going to insist.
280.
Yes, I'll take my lord. Let me complete this. I won't take too long, but I will have to complete. Page 280. This, my lord, with regard to I'm conscious my lords are sitting in the vacation.
No, that,
But I'm also conscious that, my lord,
if it was
people.
a vacation, we wouldn't have sat on a Sunday.
Yes, no, I bow down to that. I'm grateful. We are grateful. But what is important is human lives have been lost, which will never come back. People are put to utter misery. Because of what? Because of not doing what they're supposed to do. Page 280. These are, my lord, matters with regard to COVID, etc., disposal of dead bodies, etc. There, my lords, kindly come to page 285, paragraph 1. This is a notification issued under section 122.
So this is out of the same proceedings of the Gujarat High Court.
No, this was a SUO MOTO proceeding taken by the Honourable Supreme Court.
Proper treatment of COVID.
Yes, that was the SUO MOTO matter. But since the Honourable, rather the state of Gujarat issued a notification under section 122 of the Town Planning Act, kindly refer to page 285, paragraph 1. Page code 7262 Commonwealth Statement 62 72 General Job.
Page 280.
285, paragraph 1. On 8
8th of July.
On 8 July 2021, a notification has been issued by the state government of Gujarat in the Urban Development and Urban Housing Department. The notification, which was issued purportedly in exercise of power conferred by Section 122 of the Gujarat Town Planning and Urban Development Act 1970s, contains the following directions. The buildings that do not have building use permission or or are in breach of building use permission or have violated development control regulations such as change of use, margin, height restriction, etc. The owners, occupiers of such buildings shall immediately take corrective steps to comply with the development control regulation and shall comply with the same within a period starting from today till 3 months from the last date of applicability of the Gujarat Epidemic Disease Act and so on. While all the municipal, corporate, Nagarpalika, urban development authorities areas shall take appropriate measures to increase compliance with building use permission. However, no coercive action shall be taken against such buildings for breach of development control regulations from today till 3 months from the last day of the expiry of so and so. So, applicability of the Gujarat Epidemic Disease COVID-19 Regulation 220, last day 3 months. Now, 2. Section 122 of the Gujarat Town Planning and Urban Development Act 1976, which has been invoked for issuing the notification, is in the same terms. Then that is report I refer to, I don't refer. Now, kindly see number 3 and 4. The power which is vested in the state government under section 122 is to facilitate the efficient administration of the Town Planning and Urban Development Act 1976. As a consequence of the notification dated 8 July 2021, the state government has directed that buildings which do not have valid building use permission or buildings which are in breach of building use permission or buildings which have violated development control regulations such as change of use, margin and height restriction shall be exempt from the obligation to comply with the building control regulation for a period of 3 months from the last day of the applicability of the Gujarat Epidemic Diseases Control COVID-19 Regulation 2020. Though the notification states that in the meantime, corrective measures shall be adopted to comply with the regulation within a period of 3 months, directions have been issued to all local bodies in the state of Gujarat to take no coercive measures. Now, number 4, finding of the Honourable Supreme Court. Prima facie, the notification dated 8 July is ultra vires the provisions of section 122. Such an exemption for complying with the building control regulations, which have been validly framed under the town planning legislation, bears no nexus with the efficient administration of the Act. Granting exemptions from complying with development control regulations which are made in public interest to promote the health, safety and welfare of citizens defeats the letter and purpose of the legislation. Condoning the gross irregularities in constructing buildings which do not have building use, or as the case may be, fire permissions, has resulted in the violation of the law to the detriment to public health, as is evident from the incidents of fire which have taken place both in Rajkot and Bollywood. Many others took place subsequently. The state of Gujarat shall take, now this is the direction, the state of Gujarat shall take proactive steps to ensure that the rule of law is observed. So, my lord, and then the notification state. But if this direction which has been issued by the Honourable Supreme Court, my lord, in
27th August.
27th August 2021, and which has not been vacated, modified, annulled in any manner, is binding on the state of Gujarat and its authorities. Therefore, my lord, shall take proactive steps to ensure the rule of law.
Yes.
If this is what is directed by the Supreme Court, Honourable Supreme Court, fire safety, building construction, etc., has to be implemented. While they were told that this we are staying, the notification is stayed, that exemption is stayed. So this was bound to be followed. So therefore, Honourable High Court's direction which I pointed out, this order which I'm pointing out, would therefore require that the law has to be followed and implemented. Now, my lords, coming to the current proceedings, the main matter. Kindly come to page 60.
There, if Mr. Panchal will permit me, because this has been virtually hijacked.
But my matter is going on. Please wait.
I think you are now referring to SUO MOTO, sir, if I have heard properly.
No, you hear improperly. I'm referring to my matter. Judgment going on. Kindly please wait. Page 60. This is what I am supposed to not say what I'm saying. Page 69.
What is the main matter?
Well, this is my civil application is filed in the main matter.
Why do you want us to read the main matter?
Because directions have been issued by the Honourable Division Bench and assurance was given by the state. I may not refer. They are otherwise binding. statements were given that we'll take steps, etc.
After the 15/12/2020 order,
Yes, my lords.
which is that order,
Yes. There are a couple of orders.
you have annexed it with the civil application,
Yes, yes.
then show us from the civil app.
I'm taking my lords to civil application. I'm sorry.
Page
The 69.
page 16. No, no.
Page 70, if my lords, very quickly, I won't trouble my lords with more time on this aspect. Second paragraph, page 70 is reported by so-and-so, and as stated by the learned so-and-so, that on account of the orders passed by the rights so-and-so, etc., etc. This is done. Then my lords may come to the next. This was, of course, referring to hospitals, doctors, etc. Now kindly come to 92. Yes. The orders passed where various corporations have given assurances. So that is the order dated 4/4/2022. First paragraph only. While direction of 15(2) have been complied with regard to hospitals. Page 89 also. You have not been permitted to be occupied or continue to be used. Respect of various buildings are going on. Then, my lords, I would refer to Rajkot at this stage, which is on page 95, paragraph 6. My lords, paragraph 6 on page 95. This is with regard to Rajkot Corporation. Further affidavit filed by the Municipal Commissioner, Rajkot Municipal Corporation. So, respond number 8 in the original proceedings. Would it please also disclose 1021 high-rise building located in city issued with NOC fire safety certificate and
Go to page 115, para 6.
not true. This is the final order. Having perused the affidavits filed by the Municipal Corporation, Jamnagar, Vadodara, Gandhinagar, Junagadh, and Rajkot, we have to consider the steps taken by the do not seem to be not with utmost seriousness. We see so for the simple reason that in respect of so and so, etc. buildings, except stating that they have been issued with 3 notices in Waterworks Department and direct. This is with regard to Jamnagar. Departments have been directed to disconnect the water supply. There is no material placed on record. Then, my lords, first line. I'm sorry, I may read this. There is no material placed on record to establish it to whether the municipal corporation has taken step to seal down the said building as subsection 1 of section 25 of the Gujarat Fire Prevention and Life Safety Measures Act 2013 empowers the director or the regional officer or the chief fire officer, as the case may be, to take such steps without prejudice to the initiating prosecution against the offenders. In fact, no steps have been taken against persons who are non-compliant by initiating prosecution. Kindly come to paragraph 7 on page 117. I may skip the first lines, few lines. Well, anyway, I'll skip this 122 because this is regard to Ahmedabad. Then 122, paragraph 6. This is what this may be relevant even for this. Paragraph 6. Yes, paragraph 6 on page 122. This while referring to a fire incident. In the light of the fire incident that occurred on 28/11/2021, which has been noticed by us here and above, we are of the view that it is high time that the authorities would take immediate steps, at least in respect of high-rise buildings which are lacking non-compliance by the fire certification or building is permitted, as well as tears shed by the state, etc. And then, my lords, page 123, taking drastic steps, sealing, etc. would succor. This is also mentioned.
One important thing, Amit bhai, you missed on page 122, which is in bold, third line from the bottom. As such, the principle of prevention being better than cure, which is always missing so far as we are concerned.
I understand. I'll refer to it. As such, the principle of prevention being better than cure, it would be apt and appropriate that authorities would at least take immediate steps.
That is not happening anywhere.
Now, my lords, kindly come to page 131.
Until next 2 minutes, we will stop.
My lords are taking a break.
No.
Then, my lords, if my lords don't want me to, I will address on submissions because probably my lords don't want, because my lord, the record is bound to be bulky because it is gone on since, I don't know how many fires, how many deaths.
131 para 3.
Yeah, that's okay, my lord may skip that. My lord, what I am trying to say is, there is no dispute, even without referring to the number, that persons have died. There is no dispute that, and I don't think that any inquiry is required to be initiated in the fact whether persons have died or not died. There is a certain event, unfortunate, which has caused death because of whatever reasons which my lord may call upon the state or the and the corporation find. Lord, what action has the state taken against those officers? Does it require even a minute? They have to be suspended, my lords. If not dismissed at the day.
Mr. Trivedi,
There is one
you cannot-
development.
Mr. Trivedi,
No, I'm not
kindly-
interrupting, sir. I'm appraising that one assistant town planner, one assistant engineer, deputy engineer of R&D department, and 2 senior PI of Rajkot police are suspended today, knowing fully well that this will be argued.
Correct.
So I am saying, my lord, there is whatever my learned friend says, I don't dispute what he's saying. I cannot because I don't know.
Cannot.
I cannot because I don't know what he's saying. But my lord, what I am trying to say is that the state government, the corporation ought to have taken initial steps on the very first day. What inquiry is required to establish that people have died, accident has taken place, or mishap has taken place? Why no action? And my lord, this is not for the first time a fire has taken place. Directions I have pointed out, this Honourable Court, Supreme Court, then why no action? What is the state government waiting for? What is the corporation waiting for?
One more fire.
Death, my lord. They only were interested in death, I think. I am saying this is murder, gruesome murder, my lord. And my lord, look at the my lord, state of families. I am sure, my lord, I am not saying that the Prime Minister, the Honourable Home Minister, the ministers, the Chief Minister, the Home Minister, they have all expressed their anguish. But my lord, action is required. People are occupying premises without permission. They are in the city of Rajkot. They are visiting, or maybe they are at least noticing. But one more aspect, legal aspect. There is no power with any authority to condone, substitute any provision of the Gujarat Town Planning and Urban Development Act, GDCR, and my lord, the Gujarat Fire Prevention and Life Safety Measures Act 2013 in any manner by any authority of the state. There is no statutory power. One more aspect, my lord, I was somewhere stated that these persons, because they were existing since prior to September of the Regulation Act, they have applied for regularization, and regularization has been permitted pending whatever. My lord, this Gujarat Regularization of Unauthorized Development Act, the earlier one as well as the current one, which is in force, does not permit regularization in absence of fire safety measures. Now, this is one legal contention which I would request, my lords. Under what provision were they permitted to occupy? How could they have been permitted in absence of permission? And whether any order has been passed to regularize or to permit occupation because of the Gruda 2023.
That's all.
So, my lord, no, I have prayed in paragraph 11. Kindly refer to my prayers. But this is a civil application. Pending the main.
Para 11 ABCD.
Yes, ma'am. My lords will call for the report, or has already called for. Then, my lord, C. Directions against persons accountable, principle of public accountability, and, my lord, in view of the non-compliance with the directions of the Honourable Supreme Court, this of the court which I referred to, my lord, Justice, and the statutory provisions have not been complied with, my lord, action is required to be taken against this. I'm obliged.
Yes, SUO MOTO, we'll take up, so they will
Yes, yes.
answer in this
My lord, just one.
Yes.
halfway, both matters, and then
Yes.
answer.
My lord may grant the draft amendment.
That is granted.
I'm obliged. I have served a copy to my lord.
May I, sir, with my lord's permission?
Yes, Mr. Devnani. Yes, Mr. Trivedi, just a minute.
Please,
Let
my
us
lord.
see the
I
petition.
have fortunately received late in
Yes.
the evening all the things and I have served most of the people. The names did not come forward from the registry. Anyway, Mr. Panchal helped me. No issues. All the corporations. Now, if the writ issued yesterday is in the file, if my lord will be kind enough to turn to the writ issued yesterday, conspicuously 4 names of chief officer, chief fire officer of respective corporations is missing in the writ, though it is there in the cost item at 11 to 14. They are there. I pointed out to the concerned officer who was instrumental in sending me the writ. Still, I did not receive the writ qua the concerned chief officer. So today they may take a stand that though they are party 11 to 14, they are not served with the notice. I hope such a technical stand may not be taken. That is one. Now, main issue was with regard to this unfortunate incident for which the SUO MOTO is taken up yesterday. If we see the entire proceedings which took place yesterday during the entire day and overnight also, 2 JCBs were brought. Now, this is a very serious site of accident, mishap, of fire, and unless and until all places are properly photographed and videographed by forensic expert, what was the hurry in removing the evidence from the site? The manner in which the police officers have removed everything from the site is a very serious indication that somebody wants to see to it that the entire evidence at the site is immediately destroyed before everything is collected. That is one very important aspect which my lord should go through all the videos. I will be trying to collect all the videos and place it on record by way of pen drive. And as it will be evidence from some other source, I won't be required to file 65B certificate because it has run through the entire day on various news channels. That is one. The other serious aspect was that the hurry in preparing the FIR. Now, certainly government would like to make a show that they have taken the issue at very quick, as a very quick measure. They prepared the FIR at 3 a.m. Then why not in the evening? Bodies were yet to be found. Exact number of count, which the FIR mentions is at 27, may increase. There are still families who are coming out with the interview that their family members are not found. Let us hope that from the debris, the body parts which they have collected, bones, etc., whatever remain, the DNA matches and only 27 are found to be dead. Let us hope that number does not increase. Where are the other missing persons? Their mobile might have been destroyed, but if they are alive, they would come forward. So what was the hurry? They could have waited for a day. They only included 6 persons who are named owner, and the 7th column is left that whosoever is found. As Mr. Panchal rightly pointed out, that by various orders in fire safety measure petition, which has been going on since 1997 originally, and the latest one is from 2020, unfortunately, we do not find in any accident the responsibility of officers of corporation, concerned police department who was supposed to take certain preventive measures as per the act, as per the rules, as per their guidelines, notifications, circulars. Now, when they will be roped in, we have seen in Harni Bodkan, in Morbi, that those who are controlling the local authorities are the last persons. Fortunately, in Harni, the Honorable Chief Justice did direct the inquiry as per the IAS officer's rules with regard to the then municipal commissioner. There will be three sets of people who are responsible. Those in whose time this entire thing has come up. What were they doing? And who will be roped in, sir? Today I just received the news that assistant town planner, assistant engineer, deputy engineer of road and department, two senior PI of Rajkot police, whether they are the ones who were there at the time when the entire thing came up, whether they are acting as officers today. There will be two sets of persons. Those who permit, do not keep their eye open, permit it blindly. They may be transferred. Some might have retired. What about those who are there, who were there at that time? They don't talk about them. Only those who are right now available are made the scapegoats. They also are responsible, no doubt. Everybody, we don't want that every morning the one has to rush. Now, if we see the latest video of how the entire fire caught, the welding work was going on. Now the owners, not only owners, but the authorities should have seen that if some work is going on, work of a building, at least they should have removed the thing which were inflammable just below the same welding area. That's how it caught. The plastic sheets, etc., caught the fire so urgently. It is not that the people who were working there did not try to prevent it, but the manner in which the fire took, say, speed was very shocking, and they simply ran out of the gate. That was the entry area. In an entry area, when the CCTV footage shows clearly that such huge fire takes place, and there are sheets of, say, plywood, acrylic sheets, plastic material, totally inflammable, then where was the chance of anybody going out? There are people in the air-conditioned restaurant from where the video we are able to see, sir, which I will be placing on record. The father of one person rushed above. He is also now dead, as reported. So such serious incidents which take place when under the nose of the authorities, and the authorities, as my friend rightly pointed out, we see from Instagram photographs of those concerned DCP Zone 1, the then municipal commissioner, they may go. Everybody goes to inauguration, free food, invitation of high officers. Everybody likes to make a show that they are very respectable people and authority. They would like to go for inauguration. Did they verify that the place where they are going for inauguration as chief guest is having requisite permissions? As soon as they received the invitation, they should have at least taken that care. That before we go to such a place, do they have the requisite permission? They don't take that seriously. And therefore, they are more responsible. Now, generally we see in such accidents, we invoke 304 Part A, culpable homicide not amounting to murder. Somebody will say that this gaming zone was taking signature of each entrant, that anything happens to them is their responsibility. Sir, we studied law of torts. The well-known maxim, voluntary non-fit injuria, would cover only that part wherein they participate in a game. If I go to go-karting and two cars collide, that is the purpose of that game, and if I get injured, that will cover that. Not such fire which is by way of accident and negligence on the part of those who are going on with the activity of welding, etc. That cannot cover these things.
Yes,
So,
Mr. Devnani.
this, please,
Well,
my
I
lord.
will not take much time. But I will take only 2 minutes of your lordships. But this unfortunate incident today, only in my humble submission and subject to it meeting to the approval of your lordships, will require two immediate steps. One is preventive and the other one is corrective measures. This unfortunate incident has occurred. The first submission to the Honourable Court
Mr. Devnani, I think
Is that-
please wait. I am in the middle of a serious submission.
No, I have said, I have told Mr. Devnani to get
Sorry.
it started.
the
My
first
apologies.
submission to the Honourable Court is, the statement today declares before your lordships that this structure which came into existence, which was widely publicized, influencers were called, and people were, in fact, it was advertised. What were the permissions required for this structure to come at a place, and which are the authorities who were required to grant such permissions? That is the first thing that the state will have to declare before my courts. The second thing is, my lords, that if the authorities, if no such permissions are taken from any of the authorities, then who the state believes is responsible for continuing this game zone or recreational facilities? I am told that, though it is in media reports, I am told that for a particular day, the entry of 500 was reduced to 99 and a lot of people had come. Now, who is responsible for these structures to come up and continue? The second submission to the Honourable Court is, as far as accountability part is concerned, somebody is accountable. The state will have to come before your lordships and say that these persons are accountable. And in today's scenario, the submission to the Honourable Court is that this will call for some drastic steps to be taken. Because this cannot...
Who will take the drastic steps?
I am obliged. That is one. And against whom? And against...
Honestly speaking, we do not have faith in the state machinery now. After 4 years of orders passed by the orders of this court, directing them their assurances, this is the sixth incident that has happened in court.
Nothing has happened.
And unfortunately, sir,
And the corrective
Only
steps.
they want lives to be lost and then they trigger the machinery.
Correct.
I feel India has no value, sir.
Mr. Trivedi, please keep quiet, sir.
There is one
Yeah,
more...
Sir, I think as an officer of the court,
Yes.
I was in the middle of my argument. My
Correct.
lord has every right to stop me and ask anybody
We
else
are trying to only associate with these sentiments that you are expressing.
Sir, I understand. I was pointing out one very important thing in para 10. I had a detailed talk with Mr. Devanani in the morning. Para 10 of the SUO MOTO. Para 10.
Kindly show.
But that will require one
Page
amendment.
five.
I have stated
Page
that
five.
all
We
of
will
a
require
sudden
one.
the fire had occurred.
Dharmesh
My
bhai,
sense is-
please have some patience. I understand that we discussed in the morning. Para 10, sir.
Leave
It
to
would be appropriate. It would be appropriate to refer to a report indicating that the plywood and other construction material lying in the game zone caught fire all of a sudden. It was not all of a sudden, sir. As we have seen the video since morning yesterday, welding work was
leave
so we
to
will. Yes, deeply obliged, sir. I will send the amendment to Mr. Devanani. Now, what I was requesting yesterday to my lord was that all municipal corporations and all local authorities, including 7 municipalities, local body, what I have found yesterday, sir, during the course of the day, that everywhere such gaming zone has come up, not only in 4 municipal corporation areas, but
Yes.
everywhere, even in small towns. A Gandhinagar corporation has 21 such facilities. So I would request today that my lord may direct inclusion of all municipal corporations and local area authorities. So all collectors across Gujarat. So we may not have to individually add anybody else. State government will certainly be seen, and whichever the local authority is there, they will be permitted to engage their own advocates.
What the state of
Because like the Honourable Court, many have lost faith in this state government.
Yes, who appears for the Rajkot court?
Mr. Virk, as I understood.
Yes.
No, sir, I was in the middle of pointing out certain things before they take over. Because
No, Trivedi, it's enough. It's okay. We have seen it. We have seen it yesterday also. There can be nothing more than what it is apparent. Whatever is there is there.
sir, I was pointing out something which is not there.
What is
The
there?
manner in which police registered the FIR at 3 a.m. after the visit of the Chief Minister and the Home Minister. What was the hurry in registering the FIR at 3 a.m.? That is one.
You have already
What
said.
was the hurry? What was the hurry in removing the evidence from site by JCB machines?
Rajkot Municipal Corporation. No,
Milord, may I address you?
no. First the Rajkot Municipal Corporation. You can take over from all of them.
I want to first,
There
no
is no-
difficulty. I'm only endeavoring to address the honorable court on the larger question. Which
We'll come to the
Honourable
larger question. First come to the Rajkot Corporation.
Rajkot Corporation also, Milord, I'll address him,
Let-
or let him address.
Yes.
immediate measures which we've taken.
They were,
I believe we will be able
certain
to-
issues in our order yesterday.
There are 2 or 3.
The land on which the TRP is in, that game zone came up. Who was the occupant? What was the use? Permission use was there.
The permission has not been sought from the corporation. In fact, I have a note ready because this has happened in the last 12 hours and all my officers are actually on site in the rescue effort. There is only one submission to be made at the answer. In fact, on the 9th of May, on an application made by the original landowners for regularization of the construction.
Then you are not aware of the whole TRP game zone existing in the.
Lordship, I am coming to that. What I am wanting to respectfully submit is on 9th May, the corporation specifically raised queries, called upon the owners.
Till then you are ignorant of this structure existing in the within your vicinity.
They have not applied to the authority.
So you were blind to that. That this big structure existed, you are not aware of it.
In my respectful submission.
What is the corporation's explanation to that? The whole zone existing for the last 2.5 years or 18 months.
It is operational since July 20.
Was fire safety applied for?
They did not apply for it.
So did you inspect?
Because they, so
When the
therefore,
ticketings were done, were you aware of that? The entertainment authorities under the entertainment tax, etc., were to be.
they have taken,
So we take it that you are completely turning a blind eye to the whole issue.
no, they have taken a certain required permission.
When did the corporation first recognize the existence of such a game zone?
They applied for it for the first
Till then
time.
you were completely ignorant of such a structure in the entire vicinity.
For the first time, they apply only on.
Were you
4th
not
of
aware
May.
of the orders of this court under the fire safety,
We were aware.
under the PL? Then what were you doing?
On 4th May, the owners of the land apply for the
There are
first
media
time.
reports that your municipal commissioner at the time of inauguration went there. We can't take judicial notice of that fact.
Lordship there,
Then for 18 months, what did the corporation do?
the owners are.
Sat over it.
The owners are said to be utilizing this land for this gaming zone first standalone as a go-karting area. I may take,
Permissions are
I
sought.
may take 2 or 3 minutes.
You argue.
I may take 2 or 3 minutes. The owners are said to be occupying for the first time originally for go-karting. Then they construct ground plus first floor structure
Without permission.
without permission.
That
You don't-
go-karting,
Is
That-
in the adjacent parcel, Lordship.
in which year?
It is said that it is in June 2021 onwards that this started.
Go-karting.
Go-karting plus other activities in the open, and then the structure is set up.
In the month of June 2021.
June, July 21. I have prepared a short note due to
Thank you.
paucity of time.
He did not share it.
Nana Mova.
Nana Mova. Now, please see item 3 on page 1 for a moment.
Item 3.
The table.
Yes.
Particulars of unauthorized construction. As per the plans submitted by the owner as part of their application dated 22nd April. This is what they have established. Honorable Court may turn the page. The nature of the structure as is prima facie evident is
Steel frame.
fabricated steel frame. So it was not civil work. Honorable Court may directly come to the dates. The dates may assist the Honorable Court.
Page 2.
No, yes, page 2.
Key
the
dates.
Key dates. Now, the owners have been operating this originally as a go-kart, and then they have created a structure since June 2021. On 22nd April 2024, for the first time, they made payment of a certain fee. The Honorable Court will have the payment receipt also at page 4
100 rupees.
of 100 rupees. But item 3, they then applied under the Regularization Act for regularization on 4th of May. Now, I may directly request the Honorable Court to have this application at page 6 of the note. So this is 4th of May. They apply for the first time. It is a bulky application.
Yes.
And to that on the 9th of
Is it
May,
under the Gujarat?
regularization of unauthorized.
Regularization of urban.
Now, although Mr. Panchal said that there is
So for 3
regularization.
years, you did not inquire about the structure, the legality of the structure. Forget that they did not apply for permission. Forget. What are your duties?
Lordship, my respectful submission is the Honourable Court.
Who is the officer in charge
There
during
is a-
this period, 2021 to 2024?
I will take instructions. The
What instructions?
The estate department is.
What
generally-
instructions will you take now?
The estate department is generally required to see, but this was operating under.
What steps have you taken against that erring officer? For not taking any inspection between 2021 and 2024?
Lordship may allow us some breather for that.
We want reply.
Because
What actions have
the
you taken?
entire machinery is devoted to the rescue effort for the last 72 years.
After the things have happened.
My respectful submission is please see page 9.
And before
Only
this-
page 9.
Page
Only
9.
page. I did not grant the application on 9th of May. I
Ask
wrote
for
back,
detail, saying that
I sought information. Item 8 may please be seen. Society NOC, airport NOC, fire NOC Raju Karvi. I actually sought for the fire NOC because without this information, even regularization could not have been considered. They had not applied to us for fire NOC. There are other establishments within Rajkot as also within Ahmedabad and Baroda where fire NOC for such game zones has been granted.
No, just 1 minute.
So
I'm
it is not.
Sorry to interrupt. No, because it's on regularization. I have given the provision. They have asked for information. He says, the corporation says that fire NOC was or fire application was never made. They are aware of the fact that fire NOC has never been applied for, building use permission has never been applied for. Kindly look at the provision section 8.3. I have given the act. Circumstances in which unauthorized development shall not be regularized, because tomorrow it can be done, my lord, by somebody else.
It will never be
No,
regulated.
not by you, madam. It is by Rajkot Corporation.
We would.
One minute, one minute, 1 minute. With some knowledge, I'm saying this. It has been done in the past. Well, Lord, may I have a look at page 7 first? Just one.
You could have ordered closure of that game zone till the regularization.
Lordship, that is one question that immediately came to the commissioner's mind also after we saw.
After
this
the
paper.
incident.
Well, just
That
1 minute.
At least as on 9th of May. that-
Before my learned friend.
I found out.
Well,
At least as on 9th of May. it
Yes.
would have-
my lord may just permit me for a
We
second.
are
Just please.
evaluating the circumstances
Guru,
under which that.
No, please.
I think, Mr. Vivek, you don't first supply anything and then you stop somebody from pointing out the relevant provision. This is something absurd. You could have even still sent the.
Ek minute, Brijesh bhai, with your permission.
8.3.
Well, page 7, section 8.
In the.
Are, Brijesh bhai, 1 minute. With your kind permission, please.
દરેક મેટરમાં અમિતભાઈ આમનું આ સ્ટેન્ડ મને ટાઈમ આપો બસ ટાઈમ આપો
Section 8, my lord, page 7.
Please explain where-
I'm sorry, there is one copy only. My lord, may. Sorry, I'm so sorry. Circumstances in which, well, this is the Gruda, which came into force on 1st October 2022.
Correct.
My lord, sir. Section 8, circumstances in which unauthorized development shall not be regularized. Number 1. Now come to next page, number 3. 8.3. Numerical 3. An unauthorized development shall not be regularized if it is inconsistent with the provisions of the Gujarat Fire Prevention Life Safety Measures Act.
They must have taken some stability certificate from some department.
not.
That is what the newspapers report,
They have
on the
not.
basis of which.
But my
They
lord,
have not.
the commissioner would be aware of Gruda.
And
Where is
in
the
fact,
question of asking for fees?
Therefore, at page 9, if the honorable court sees item 9.
That you are asking for an NOC.
No, item 9, handwritten item 9 at page.
Structure stability certificate.
The
registered.
corporation actually
So
sought,
admittedly on the date when the incident occurred, there was no NOC,
there
there
was
was no
no.
structural stability certificate, there was nothing. And it was merrily going on in the eyes, in front of the corporation.
My respectful submission is.
This is your submission.
This is not adversarial
I
and there
agree.
cannot be no, there
There
cannot
can
be
be
a
no
defense
dispute
to
on.
this unfortunate.
Yes, what about Ahmedabad and the other corporation?
Lordship, for Ahmedabad and Vadodara, I appear.
Yes.
For Ahmedabad and Vadodara,
Your students started going around and shutting down those gaming zones now overnight.
there is
Now
substantial.
you have pressed the panic button.
No, I have a list ready for the honorable police for the three corporations.
For this is for Ahmedabad, Baroda, and
For Rajkot, Ahmedabad, Baroda and Rajkot.
Rajkot you have given. This is for,
So Rajkot, the first notice qua this incident alone. Now, if the honorable
This is
court
for-
has this,
for Rajkot.
this is for the honorable court may have the first page. Ahmedabad, Baroda, Rajkot,
Okay.
all gaming zones and their statuses. If the honorable court can only illustratively have a look at page 1. Guru, ek copy de.
Lord, why doesn't he share now also? He can easily share.
I
By
have
sending
given it,
on
Mr.
WhatsApp.
Trivedi, you are not in Ahmedabad. I did not know. You told everyone that.
I
you
think,
are back in
sir,
Ahmedabad from Udaipur.
have some manners. We are in court. We are live. You
So,
can
the
send by
honorable
WhatsApp. I
court
sent to you by WhatsApp. So don't talk in this tone.
Then can you?
Honorable court may have page
I
1.
think he should be taken to task for behaving in this manner, sir.
The honorable court may have page 1 as an illustration.
He must send to me right now on WhatsApp. I served him through WhatsApp.
Honorable court sees illustratively. For example, in the city of Ahmedabad, there are in all 34 amusement centers, gaming zones. And there is a large substantial bulk which has taken both fire and bees. There are some which have not. I have admitted that also.
Whether fire permission sought.
If yes,
And they have
whether
been
grant.
given. Which are the, is, page 1 is what?
So this is Ahmedabad. Page 1 to 4 is Ahmedabad. If Lordship sees illustratively, there are,
But are you inspecting them regularly?
because till then the fire NOC is not renewed every year.
Then
Can you indicate the category of the building in which this is granted? Because I am under the impression it is under mercantile too, because that will have relevance to the required measures.
So
As far as
that also I have taken instruction.
please tell me. Or
The
tell the honorable court.
to have the GDCR for a moment, part 2.
judicial part. So your submission on Ahmedabad is that most of the game zones have permissions of BU and fire.
Fire. There are 2 or 3 which don't. I have said that also.
Have you been inspecting those fire?
They have been in, because
How
still.
often? Now
Lordship, I will
suddenly
put
because
it-
the fire occurred in Rajkot, you started.
No, I will put it on affidavit. After the fire occurred, indeed we did a
And you found,
committees.
and you found many game zones which had only one exit.
We have shut them
Mr.
down.
We cannot,
We have shut them.
we are human beings
I bow.
and we cannot sometimes ignore news reports or television channels. We may not go by that.
I,
But we are aware of what is going on.
I bow.
Do you ask for?
Only
the-
one-
some
only one
rough
question,
sketch
sir,
or
if I'm
layout
permitted to
before,
put.
before giving any
Shopping
permission?
mall.
I'll answer both.
Only,
The honorable court.
one
has
before,
part
before
2,
Mr.
11.
Before Mr. Virk
Mr.
answers, I have
Trivedi,
Mr.
Mr.
Trivedi,
Trivedi,
kindly,
please.
only one query, sir. As
Please,
my lord has rightly asked, only one query, so that he can answer both.
Mr. Trivedi, please let him reply first of all, then we will hear you.
એનો સાહેબ પ્રશ્ન છે આપણે જો વાંધો ના હોય તો Mr. Vic made a statement just before a few seconds that there are 2 to 3 which do not have permission, which is put on record. Have they taken any steps before this mishap? No.
Yes, Mr. White.
I'll answer both queries. First, my lord Justice Vaishnav's query. GDCR point number 2.
Page,
Part 2, page 11, 6.1. My oral instructions are, if the honorable court has table 6.3, use permitted in each category. My oral instructions are that as far as Ahmedabad is concerned, if my lords were to have items 30, 38 and 39, 38. So 30 is temporary use, 38 recreational use, and 39 sports and leisure. When an applicant approaches the corporation for a gaming zone, which is an indoor gaming zone, then it is after inspection evaluated in one of these 3 categories, Lordship. If it is having temporary structure, even then there is mechanism to seek permission. Now, this is oral. I would put it on affidavit.
yes.
If my lords were to broadly see the second note that I have circulated,
अभी जो ये वाला
Please.
Just 1 minute, sorry. No, because it doesn't fall in this category. 30, 31, 32, what my learning friend refers to, kindly see what is indicated, what
30,
use.
38 and
39
30.
pages.
Sorry?
30,
And he doesn't supply the
39.
second set also.
39 you.
So let's look at 39.
Amusement park chair.
This is
39
his submission.
Very well, let him, no, but it doesn't fall. Let them say that it falls in the amusement park.
Temporary use, fair, circus, exhibition, mela, pandal, fisheries related activity. Correct?
And 38 and 30.
38
Very well,
is
anyway, my lord.
recreation use, natural reserve and sanctuary. It is a natural reserve.
No, it is not a natural.
What is a racetrack, shooting range,
39, the honorable.
garden,
I may not go
recreation,
into-
nursery, botanical garden,
Through your instruction.
sports and leisure,
Honorable court may have
39.
30, in 38, there is recreation and in 39 sports complex.
So recreation use is
Amusement park,
further classified as uses of natural
I bow
reserve.
down, I bow down. Therefore,
sports and leisure.
39.
Let him put it on affidavit if he's so confident.
Correct.
ભાઈ એમને affiliate માં તો સમય જોયા જ કરે છે વિશ્વ
Let him make
પંચાયત.
a point and then we'll see what,
Very well.
we have all come in 12 hours
yes, yes.
to the best of our ability.
But after that, of so many persons. No, what does they mean by saying 12 hours? He's not doing any
I
favor.
think Mr. Wilk is in the habit of seeking time and nothing comes on record even after he gets long time. That is my experience in Harni.
Sports
It is his habit
pool,
of
playground,
not-
camping ground. Mr. Trivedi, now kindly keep quiet. Let us
Sir,
understand what
I'm
Mr.
pointing out the behavior of this advocate in not even sending me the notes on WhatsApp,
Yes,
even after I saw him.
please
This
send-
is very sad.
please send somebody on WhatsApp.
I'll do it. I'll do it in 5 minutes.
Sports complex, swimming pool, playing, somebody is sending it to you. Camping ground, facility for water sports, theme, amusement park. So maybe an amusement park according to.
And this is evaluated based on the nature of activity. For example, if the court has the second note and looks at page 7, just to show a broad spectrum of the activities that generally take place at such places. This is Rajkot. Page 7 is Rajkot. Now, if the honorable court has the third column, the recreational activities at the establishment. These are the other centers within
They have
that.
no view for,
No, they have no view.
all of them have no.
No, there are some which do. If the honorable court sees 6, 7, 9. I wanted to place a fair picture before the honorable court. But what I wanted to show is so that my lord justice Desai's query is also answered.
6, 7, 9 have view for me. Most of them do not have.
In Rajkot, this is the situation. Honorable court sees the nature of activity.
Where in the trampoline, bumper car.
Now,
General
depending on this and the structure, my instructions are that an evaluation would be done if a fire NOC is sought for. In this case, at the TRP game zone, fire NOC was not sought for. And the application for regularization is made only in May.
That is your short view.
And since when this game zones are in operation?
Lordship, we are evaluating that. Some are in operation for a little over a year. We are gathering the data as far as when they started operation. The
And
BU
for
permission.
during that period, what inspections did you make?
Lordship,
Neither.
in cases. where-
Even if no permission is sought for? It is your duty. If somebody doesn't ask for the permission for 2 years, 3 years, 5 years, will the corporation shut their eyes?
You don't take a walk around in the corporation, on the city, the corporation.
Honorable court,
Don't go around and see the structure, suddenly what happens, or you only go for when something like this happens. Yes, Surat,
yes, I'm just sending the note to Mr. Trivedi.
please do that immediately.
Highly obliged, sir.
Surat,
So for Surat Corporation, sir. For total 12 safe zones are situated. The territory of the Surat Municipal Corporation. Not all 12 zones have secured the fire NOC. At the relevant time, the corporation is after verification, fire department had issued the NOC. After the incident took place in Rajkot, the corporation department, concerned department had visited 12 zones. somewhere we found that after securing the fire NOC, some lacuna we found, like DGVCL electrical certificate or some load standard was not maintained. So out of 12, we have sealed the 10 game zones. Somewhere we also found that fire system is not properly working, or the fire alarm system is not working. So we had sealed those properties. But before, my lord, I further submit, I would make it clear, my lord, the corporation is not issuing the permission for game zone. See, the procedure under the BPMC Act and GDCR is any person come before the authority for development permission granted in two types. One is for residents, another is for non-residents. For example, my learned senior friend Mr. Panchal had drawn the attention of the court. Table number 6.3, Mercantile 1, Mercantile 2 and 36, I also invite the attention of the court. They coming before the corporation to take the permission of shopping complex or shopping mall or like a sport complex. Corporation issues the development permission after necessary verification for construction. Thereafter, if the construction made in accordance with the sanctioned plan, they come before the corporation for BU permission. Corporation only verify whether the construction in accordance with the sanctioned plan, corporation issue the BU permission. After BU permission, the developer or whoever have made the construction may sell the property.
So these your game zones are in the mall. All these 12 game zones are.
One is, my lord, as per my instruction, one is outdoor and others are indoor. So out of 12, one is outdoor and 11 are indoor.
In mall.
Somewhere in mall, somewhere separate complex. So I'm narrating the procedure. So once we issue the BU permission, at the time of issuing BU permission, we don't know for particular shop or particular showroom would be used by the owner for what purpose. So we only under the impression that the shopping complex, the permission for shopping complex is secured by the particular.
So it is your case that they sought BU for residential or non-residential purpose.
For entire building, which is.
Then they use it for something else.
Maybe. Suppose 2 shops they have purchased. So because once we issue BU permission, the person can sell the property.
So nobody goes and inquires later.
That's that I'm coming to that. So suppose some person has purchased the property for office purpose, subsequently change the purpose. Instead of office, he may start the game, 3 game video games and game zone may start. So at that time, it is the duty of the person who is running this business, game zone or whatever called they are, to secure three permissions. First from fire department, second from electrical DGVCL because Surat is there, Dakshin Gujarat, and third is police department. That is called the license. Police department will give the license. That what I gathered the information from the
police and electricity.
Fire, police and electric. Dakshin Gujarat DGVCL. The reason perhaps DGVCL, because certain games are such they consume the higher load and higher electricity. It may cause the short circuit and anything. So what corporation is concerned, corporation following the NCB, NBC, National Building Code, where in particular one chapter, I think Schedule 7 is provided for fire safety. If the building is used for assembly, then there are certain norms are there. There it is mentioned where the fire extinguisher is required, where the first aid is required, where the waste wire riser is required, where down corner is required. These all falling within the jurisdiction of the fire department. So if the assembly or the persons assembled up to 300, then the extinguisher is required. Then what are the requirements mentioned in that melody? If I Lordship permit me, I will file affidavit to that effect and mention everything. So the corporation is following all the norms of NBC while issuing the FIR NOC. But the difficulty is, my lord, when the person who purchased the property and starts this game zone, we could only able to know when the renewal of that fire measures comes into place. So every 2 years. The
For
fire
2
safety
years.
measures, fire safety.
For 2 years or for 1 year, corporation is not,
The reason is, my lord, the reason
No
is
time.
somebody starts, somebody,
no time to inspect.
no, that is not the issue. Issue is, my lord, one, suppose the property, in beginning, property was used for the particular cloth merchant, by cloth merchant or anybody. Subsequently, he sell the property. The fire department would not come to know. But when the fire department visit the complex for renewal of the fire safety measurement certificate, at that time they visit the entire property. Only that particular point of time, the corporation would come to know that this premises or this shop is now used by the as a game zone, and for that they require this compliance of this NVC. So that corporation is doing. We have visited, we have inspected the site, and we found certain lacuna. We have sealed the property.
When?
This is perhaps last 48 hours.
Before that?
Before that, so far fire NOC is concerned, it is cleared. There is no breach. My instructions are such. But some DGVCL certificate is not there, or the property is not maintained, which is otherwise required in particular manner.
Yes.
So these are my services. So corporation is, Surat Corporation is concerned, Lord.
But I have just two judgments to point out on public accounts. I have now 2 paragraphs only. Whenever my learned senior friend finishes or learned friend finishes, I refer to that. The second aspect is with regard to Ahmedabad. Ahmedabad has got many more areas which are not what my learned friend is saying. They are in malls, they are in big stores where playgroups and etc. are permissible. The games are going on. They are not forming part of the list. When he files an affidavit, I will point out that this is not included. But there, I can say out of personal knowledge also that Hamleys, for example, or some malls they are having which are not part of this list which he has just given. I don't hold him for that right now because he will file an affidavit. The second aspect which I was referring to is the police permission. Well, police permission, what my learned friend Mr. Pandya said, police permission is given for 2 aspects under the Bombay Police Act. One is for issuing tickets, and the second is for use of that area. But that is only with regard to provision of the Bombay Police Act or Gujarat Police Act. My lord, here in Rajkot, permission was given by the police only for issuance of tickets. This may be verified from the authority.
Yes, madam.
We already read their facts yesterday. The Honourable Court had called upon the authorities, including the state government, to respond to 5 major issues. So before I respond to that, I need to place before the Honourable Court, that with utmost seriousness, this issue has been taken up right away, immediately, and I will demonstrate the steps taken as an immediate measure. Should it have happened? 100% no. There can be no answer to that. What are the corrective measures? What are the preventive measures? All I will address the Honourable Court. As of now, as on this date, all gaming zones across the state have been sealed, have been closed, shut down. That is the first immediate action. Today, none of them are operational. Is this just a knee-jerk reaction? Let me point out what we have done also in the process, what we are doing, and demonstrate before this court that this is a matter which the state is taking with utmost seriousness, extremely concerned, and it is most tragic. And we will spare nobody. My lords may take it from us today within 48 hours. Mr. Trivedi is right. 6 officers have been suspended within 48 hours. 2 from the R&D department, including the executive engineer, the assistant engineer, town planning authorities, 2 from the Rajkot Municipal Corporation, two PIs from the police department who were in charge of the licensing branch. And this is just the beginning. We propose to take the most stringent action. There is nothing to be concealed. This incident occurred at 5:43 PM on the 25th. Two phone calls went, one by way of an emergency call to the police authorities and one to the fire authorities at 5:43 itself. By 5:48, the police, the 7 fire brigades with 70 to 80% persons reached the venue. It is about 2.5 kilometers. Within 3 minutes, they reached over there. My noting says 5:43. They reached by 5:48. By 5:48, 8 fire brigades reached, 70 to 80% fire personnel were there with all the necessary equipment. Also, the Kalawad Nagar Palika is the closest. Therefore, fire authorities from Kalawad Nagar Palika, rescue vans from Kalawad Nagar Palika, all of them reached the site. It was a blazing inferno. Rescue operations started immediately. As of now, as I address the Honourable Court, 28 persons have lost their lives. 3 persons have been admitted to the nearby hospital and they are undergoing treatment. So far as the requirement of urgency in filing of the FIR, that is a requirement of the law. At the process, the moment you get some respite from the rescue operation, the first information report carries its own validity. It is extremely important that the first report with whatever you have, it is not the final report. You can keep adding abuse, you keep adding material, you can keep adding sections, you can keep doing all that is necessary. But it is the first report. At 3 AM, the first FIR report, the FIR came to be registered for offences punishable under 304, 308, 337, 338 and 114. Naming below 6 persons. These 6 persons are the persons who are in charge of the TRP gaming zone, as well as who are there present as managers, etc., of which 2 have already been arrested. One, Mr. Yuvraj Singh Hari Singh Solanki, has been arrested, and one, Nitin Kumar Mahavir Prasad Lodha, who was working as the manager of the TRP, has been arrested. The FSL team was rushed immediately the moment the fire was doused to some extent, and CCTV footage has been recovered. Let me point out the details of preliminary investigation which has been carried out. The DVR of the CCTV footage has been recovered. MCB switchboard, dry blood spots, welding machine, copper wire, iron debris, foam plate, foam pieces have been recovered. So it appears, prima facie, subject to further verification, and I'll point out why I'm saying that. Prima facie, it appears that welding activity was being undertaken for establishing an extension of this, a snow gaming area, where it emits fake snow. So it's for that purpose welding was going on, and there were foam sheets under it, which is what immediately caught the fire. But this is subject to FSL reports. We, as of now, do not have the FSL, even the preliminary report of the FSL authorities. As soon as this incident happened, on that very day, within a few hours, an SIT came to be constituted. Because that is the most important requirement. We want all agencies together on board. I wish to place before the Honourable Court this constitution on the very same day and the terms of reference. I will make sure that Mr. Trivedi gets it immediately.
But never ever on time.
Mr. Trivedi, I'm sorry. I believe that you would be here.
Correct.
And not filing an affidavit.
Correct.
Because yet it is all prima facie. The reason we will make sure you get a copy of it. Rest assured, I will make sure you get it. I'll ask my colleague to forward it to you.
Thank you.
This SIT was constituted, which comprises of ADGP, CID crimes, Commissioner, Gandhinagar, Director, Forensic Science Laboratory, Chief Fire Officer, Ahmedabad, Superintending Engineer and Quality Control, R&D Department. The terms of their reference I wish to read out before the Honourable Court. And this, may read for. ખાસ તપાસ દળ આ બનાવ સંદર્ભે નીચેના મુદ્દાઓ પરત્વે તપાસ કરીને તે અંગે પ્રાથમિક અહેવાલ 72 કલાકમાં સરકારશ્રીને રજૂ કરશે. So we constituted on that very day within a few hours. અમને 72 કલાકમાં રિપોર્ટ જોઈએ છે. And further, ત્યારબાદ તપાસ દળે તમામ પાસાઓનો અભ્યાસ કરીને વિગતવાર અહેવાલ દિન 10માં સરકારશ્રીમાં રજૂ કરવાનો રહેશે. કયા સંજોગોમાં અને કયા કારણોસર આગનો બનાવ બનવા પામેલ છે, ગેમિંગ ઝોનની મંજૂરી આપવામાં આવેલ છે કે કેમ, ગેમિંગ ઝોનની મંજૂરી આપતી વખતે કઈ કઈ બાબતો ધ્યાને લેવામાં આવેલ હતી, ગેમિંગ ઝોનના બાંધકામ બાબતે સ્થાનિક તંત્ર મંજૂરી મેળવવામાં આવેલ હતી કે કેમ, તેમજ બાંધકામ નિયમ અનુસાર કરવામાં આવેલું છે કે કેમ, આ સંબંધમાં ફાયર વિભાગના એનઓસી મેળવવામાં આવેલ હતી કે કેમ, ગેમિંગ ઝોનમાં આકસ્મિક સંજોગોમાં રાહત અને બચાવ માટે શું વ્યવસ્થા કરવામાં આવેલ હતી, ગેમિંગ ઝોનમાં ઇમરજન્સી એક્ઝિટ માટે શું વ્યવસ્થા હતી. આ બનાવ સંબંધમાં સ્થાનિક તંત્ર અને ગેમિંગ ઝોનના સંચાલક તેમજ અન્ય કોઈ ઇજારેદારની નિષ્કાળજી કે બેદરકારી છે કે કેમ, ભવિષ્યમાં આવા બનાવ ન બને તે માટે નિવારવા કાયદી પગલા લેવા માટે તપાસ સંબંધમાં રાજકોટ જિલ્લા વહીવટી તંત્ર so police all have to cooperate. This is the first SIT which came to be constituted, that within 72 hours we expect a report. That report, my lord, we expect to receive by today or tomorrow. Immediately we should be receiving this. On the very same day, my learned friend's concern, Mr. Panchal's concern is right. It cannot be only to corporation areas. Lord, we have also addressed this communication on that very day. Sarva Jilla Magistrate, so all collectors, municipal commissioners, police commissioners, Pradeshik commissioners, because in Nagarpalika areas they are residential commissioners, Jilla Vikas Adhikariyo, police adhikariyo, chief officers. આ બધા પાસેથી તમારા jurisdiction-માં આ બધી જ વિગતો મેળવો. Immediately review and on anything lacking, seal it immediately. And all this is, I'm not repeating it, I'm not reading it out again. Same things. All of it. So irrespective of whether you're in a corporation area, whether you are outside the corporation area, panchayat area, and everybody across the board. My statement today is all gaming activities across the state have stopped. Further, my lord, what fell from the Honourable Court was, is this a knee-jerk reaction? What are you reacting to the situation? My submission is that post-Inni, the tragedy which occurred in Baroda, a high-level committee came to be constituted on the 1st of March, and this is part of the affidavit before the Honourable Court in that matter. On the 1st of March, a high-level committee came to be constituted. The committee decided that immediately we, for certain activities, boating, amusement parks, for sports, adventure sports, for such related activities, we need a statutory format. We need statutory rules. A statutory rule which will require a checklist, supervision, regular maintenance, regular NOCs, all of it. From 1st of May to the 22nd of, from the 1st of March to the 22nd of May, headed by the Principal Secretary, Urban Housing and Urban Development Department. As on date, 5 meetings have taken place. And today we have the draft rules. I can make that statement, my draft rules are ready. In the shortest proximate time, and I will give that meeting detail.
Ernie. That is part of a separate PIL.
No, this is not in the contract. My minutes we see, I've given all of them to the Honourable Court, the last same.
And મને બે જ પાના છે.
The last, I'm reading only the last, this. The last two pages we see. Look, the last two pages we see.
Last 2 pages.
The last page of my compiling. Just the last page of this compiling. I've given all the, yes, that's all. Is it different? I'm referring to
It's second last page she is referring to.
The government of Gujarat.
would my lords have the fifth meeting of the fifth meeting, that's the last meeting. Held on 21st of May, fifth meeting,
Yes.
yes. The fifth meeting of the high level committee chaired by the Principal Secretary of Urban Housing and Urban Development Department on 21/5/2024 at 1 p.m. My lords, be pleased to see the 16 members who are present. Tourism Corporation, Home Department, Ahmedabad Municipal Corporation, Gujarat Maritime Board, Urban Development, R&B, Vadodara, etc. Energy and Petrochemicals, Disaster Management Authority, Home Department, Fire Advisor, UDD, etc. And the last 4 points we see. A, B, C, D. Draft rules along with the SOP and the checklist for all the stakeholders are ready for the voting. The same will be discussed so and so, so and so. Ropeway rules are ready. Now C is relevant for our purpose. Rules relating to amusement parks. And this amusement park by definition in the first meeting shows it's not just outdoors, it's also indoors. So all these gaming areas fall within this category. If you have any gaming area, go-karting, that bowling pins, etc., by whatever nomenclature called, you come within either indoor or outdoor. The rules relating to amusement park under the Police Act were discussed at length with the PPT presentation by the Home Department. The rules have classified the major and minor rights, and it covers the licensing part, the subsequent operation and the management part of the activities. The chairman instructed to include 1, number of amusement parks of prominent nature in Gujarat, capacity of handling people per day for each park, the current and proposed certification licensing procedure, the current and proposed physical monitoring with the checklist, crowd management protocol as part of the enforcement, and SOPs and checklists which are to be included as road ahead activities. This is prior to the incident. Therefore, the government was sedated. Examining a formal structure is extremely soon to come.
This is only for voting.
No, all of it.
No, I'm sorry. Can you see? No, kindly see the third line of the meeting. Minutes. Well, I'm sorry to interrupt. Fifth meeting, high level committee, so and so at so and so, committee room, urban development, on the subject in public activities of voting.
Now, the amusement right.
Rights, Ben.
But to check everything. There are 4 categories.
And
Madam, they are discussing activities of water.
I'll take it from him. Kindly see.
Amit bhai, right, sir? Amit bhai, right?
Sahib, 1 minute. And
તમારી પાસે પેપર છે, મારી પાસે નથી તો ખબર છે. And some questions, sir.
See, the next page, see, rules related to amusement park under the Police Act. This is confined to Police Act. I am suggesting that it cannot only be confined because the other law is applicable. Police Act does not take away the rights or with the responsibility under the Corporation Act, the GDCR as well as
all of it.
Madam, it is not mentioned here.
Milord, it is for 4. Therefore, I gave the entire compilation.
I did not hear.
Milord, 4 kinds of activities are being statutorily regulated. One is with regard to water sport activities, amusement park, permanent and temporary arrangements, adventure sports, aerial ropeways, and these are the 4 activities for which a statutory format is coming. The statutory format draft rules are prepared, which will include the checklist for establishment, maintenance, fire. My learned friend is correct to say that fire NOC is a sine qua non, development permission is a sine qua non, and regular maintenance is also sine qua non. That is no going away from that. And that will also be included in this. All of it is part of this, a comprehensive. Therefore, you don't go to various enactments. You have a comprehensive statutory framework. That is the endeavor. A comprehensive, you make an application. Fire NOC is granted by the fire authorities. Under the fire safety.
So unless all these,
And
unless
therefore,
fire NOC and statutory framework is complete, you will not permit
No,
the
no.
game zones to begin.
yes, yes.
And then
Not-
supervision has to be done,
Yes, yes. Milord, the fire.
which is in fact not done in Rajkot. We
Milord,
can't run away from that.
I cannot.
Yes.
Milord, few more important aspects we pointed out. No BU permission can be granted without a fire NOC. My learned friend submitted that a BU permission is granted, then somebody may put it to some use, then he will.
No, no,
go
I have
for
not
the fire
submitted.
NOC. No, no, not you.
Ah.
That is not correct. Fire NOC forms part of the BU permission. No building use permission, it is part of the permit.
Another component.
Fire NOC is part of the BU permission. So it's a component of it. When you make an application, you have to put the plan for a BU permission. You have to put your development plan as sanctioned by the authority. Construction as put up by the authority. Thereafter, Milord, due verification. There is site verification. You have to put up that the fire NOC has been taken. Unless all the checklists have been met, no BU permission. BU permission is your final certification.
I'm sorry.
BU permission.
I'm sorry, disturbance. I have not made those statements. I am said that
Anyway, she's.
BU permission, yes, BU permission before fire, once fire NOC is produced, thereafter BU permission is issued.
Yes, that is how we heard it. BU then fire, it is fire bill. That is a submission. Milord, so far as the prescription under the GDCR, the order passed by the Honourable Court noted that some reporting is being undertaken or it's reported that there are loopholes in the GDCR. My submission is there is a definition under the GDCR, clause 2. My lord,
212
yes,
of building.
not. And this is the definition of the GDCR.
This here part 1.
It is-
You can want this because this is one which had your flag.
Milord, it is 2.109. I just 2.109.
That possibly is your copy with flags. The one which you gave to us.
Yes, I did. 2.109.
109.
109.
Page 27.
Page 27.
Hmm?
Page 27.
Temporary
Yeah,
structure.
right now. 2.1. Page 20. Yes, sir.
Achha, achha.
Temporary structure means structures erected for temporary purpose or ceremonial occasions such as tents, hutments, shamyanas, etc.
When you call these tents,
Cannot be called a temporary structure. By therefore, there is no question of anybody getting out of any loophole. You put up a steel fabrication over a huge area. You have ladders inside. It is covered on all sides by steel.
Correct.
How does this fall under the steel?
in fact, the building definition also, if you see,
It falls within the building definition. My learned friend is absolutely right. It falls within the building definition. Fire NOC absolutely must. Building use permission absolutely required. And my lord, we pleased to note in Ahmedabad, which stands on a better footing. I'm not putting it
Yes,
on
yes, yes.
by
Yeah,
way of
agreed.
academic.
Compliance, yes.
Milord, Ahmedabad has
In fact,
34
from the list which he has
Gaming
given,
centers.
there's sufficient compliance.
34 gaming centers, of which 28 are indoor and 6 are outdoor.
This
Milord,
is,
and Milord, after an immediate review, which was carried out, Milord, it reveals that 31 of them have the fire NOC, 3 do not.
and
And out of the 28 gaming zones which are indoor, 24 have BU permission. Of course, as of now, everything has been shut down across the
that
state.
better remain shut.
And it will remain. unless you have due permission and fire NOC, there's no question. Furthermore, my lord, the fact of the matter is, even the operators themselves were aware that it is unauthorized. They move an application on the 4th of May,
Here the operator moves after 3 years.
seeking
In Rajkot.
regularization under GRUDA. Now, GRUDA regularization cannot be granted. Section 8, subsection 3 gives reasons for which GRUDA cannot even be considered. Which includes
Unauthorized development shall not be regularized.
cannot be regular unless you have
Fire.
the state stand so far as fire NOC, my lord, is unequivocal.
Fire.
It cannot be granted, my lord. No unauthorized development shall not be regularized if it is inconsistent with Gujarat.
Except that filing of the FIR against the owners, have you done anything?
Yes, we were arrested too.
Others are,
2 people are arrested. The rest
who
is
people
the
mean
process.
manager.
No, the owner is arrested. One Yuvraj Singh is the main person who is managing.
Only one owner,
No, actually there are 6. There are 5.
five
who are-
owners.
Yes, by nomenclature, if I may give the note. It is
What
run-
about other
it is
foods?
run- I've got these details, my lord. It is run in the name of TRP Game Zone. But it was originally, there were 2 party plots. One is Ashutosh party plot and the other was JS party plot.
This TRP gaming zone was being run by whom?
The TRP gaming zone is run by both. They enter into a partnership deal, which is of Raceway Enterprise.
So what
And
actions,
the other is below JC party plot, which is being managed
so what actions
by
have
Dhawal
been taken?
Corporation, Mr. Dhawal Paitakkar.
Now, what are the actions taken against the owners or organizers of
Yes,
the gaming?
the owners, my lord, one has been arrested, the rest are in the process, all action with, they are named as the accused. The FIR records them as the main accused.
Process of arrest means what is the process of arrest?
You know,
You are looking for them,
the police authorities, yes.
are looking for them. So they are not found.
No, I don't know that. I know that I can only make a
The
statement.
public prosecutor will know.
I
Are
don't
you
know.
looking for them or they are not found?
It's not like this. Such instructions where that 2 persons are arrested.
The others are
If I
absconding.
am correct, then in today's news, I have heard that of 6 persons are arrested. That month.
So we know 3 have been arrested.
Of
by
the
instruction
6.
Of the 6.
Yeah.
And more will be, this is, FIR is only the first information report. As you record statements, as investigation undertakes.
They are based at Rajkot, all the owners, all 6 owners.
All are based.
So why 3 persons are not here?
No,
They are not
more-
found?
More will be arrested.
We are on owners only right now.
The Kankotri Mukul.
You know, the search.
Search is on, so they are absconding.
No, they will be. Nobody escapes the. Milord LOC has been issued. for-
Lookout notice. So that is
Lookout
why they are
circular,
absconding. They are absconding.
So they are not traceable.
Yes, Mr. Panchal. This is what
No,
you-
no, I just take 2, 3 more.
Okay.
Please, please.
Just 2, 3 more.
Yes.
Therefore, Milord, just in calculating the submissions, Milord. So first and foremost, Milord and SIT, which included CI, ADGP of the highest officers, commissioner of the corporation, fire authorities, all constituted. First report in 72 hours. The terms of reference is Milord exactly what the honorable court has ordered.
Exactly.
And in terms thereof, that report should come in a day or so. Pending that, Milord, my submission is As of now, 6 persons have been suspended. 2 senior officers in the town planning department, executive engineer, assistant engineer, 2 officers from the Rajkot Municipal Corporation, 2 PIs from the police department, and no stone will be left unturned. This is 6 suspensions, which is only below my learned friend said, you should at the least have suspended. Yes, at the least we have suspended them. And this is not, I'm not for a moment saying that this is the complete. We are only beginning. We are just 48 or 50 hours into the incident. We are just seeking more time. I'm requesting for time to enable me to put all this material on record.
Yes.
And what was the process? What have we been doing so far? We need to give a statutory frame. Yes, there is, my learned friend is right. GDCR prescription is there. Fire NOC under Fire Safety Act is there. But over and above that, the licensing authority, the maintenance, these are not, once suppose we give a BU at fire, we need to look at the equipment also, whether it is in working condition, whether the electricals are in order. Therefore, a composite statutory framework, because these endanger lives, we need a more detailed framework, which is in the process for which draft rules have also been
Till
framed.
another incident occurs.
It is extremely unfortunate, and we pray
Most unfortunate.
that it's most unfortunate that this should never ever occur. Over and above this, all efforts, my lord may take it from me, all efforts will not be spared. We will
For
look into
18
it.
months, this game zone was being in occupation
Yes,
and nobody knew about.
no, it cannot go without the knowledge. It could not.
Is the state government saying that?
Yes, we make a state. Therefore, my lord,
Yes.
at first blush, my lord, we have immediately suspended officers, including corporation, including.
Why should the
R&D.
municipal commissioner be held personally responsible as unaccountable in light of the orders of this court passed as far as in 2020?
Yes, that I need to, one aspect I need to bring to the notice of the
We are
court.
putting that notice to you.
Yes.
Why should we not hold the Rajkot municipal commissioner responsible for this? Accountable in light of the orders under the fire safety. Enough of waiting for 4 years. Orders being passed by this court, commissions, committees being constituted. Sit, of course, is in this case.
I only for the present, my learned, I need to make this submission. My learned friend relied upon an order passed by the Honourable Supreme Court in the context of a notification. So
Of 8th of July 21.
that was, a state government came up with a GR during COVID, saying that for a period of 3 months, we hold that we will not take coercive action. But fire NOC even then was not given a go by. The Honourable Court said no. Even during COVID, law has to be obeyed. You
No.
cannot put any statutory provision in abeyance. That GR is no longer existent. That GR has been, thereafter, Gruda came. Gruda is also under scrutiny before the Honourable Supreme Court. And
So,
that order.
Undisputedly, unless and until there is a fire NOC, nothing can,
Nothing.
everything has to come
The
to.
state government stand is, it is not negotiable. It is a sine qua non, not negotiable. No way can any establishment function without a fire.
Yes, Mr.
Yes.
Panchal.
Even before the Supreme Court, Gruda does not permit regularization without a fire NOC.
Now, my lord, as far as my learned friend's submission that it is with a
You are
resolution
going to show some judgment.
that I've given, my lord. Just 1 minute, this a minute. The Supreme Court says rule of law. Supreme Court does not say fire NOC. Supreme Court does not give doesn't give a go by to GDCR or the Town Planning Act or the Corporation Act. Number 1.
No,
No.
we are also
Arre,
not
mine-
giving a go by.
Dear lady,
She is
let
saying
me-
that there is no adversarial.
We are not giving a
But
go
then
by.
adversarial means it includes building use. It doesn't include only fire NOC. She has appeared in this matter. She's aware of this.
Today we have sealed everything, my lord, may take it from me, without requisite permissions, nobody will be permitted to operate.
The stables have been locked
This is not
after the
correct.
court has boarded.
This statement as far as Ahmedabad Municipal Corporation is concerned is not correct. This is going on.
So that judgment can you serve?
Just one. They said that everything is sealed. This is not sealed. Kindly see the notice and kindly see the report. अरे बहन पाँचों ने
Box cricket उपयोग चालू
अरे बहन
करें.
गईकाले चालू थे आज सवारे चालू.
But that.
I am not making a wrong statement. I don't make statement after getting proper instructions. Anyway, they will take steps. I am not.
She is saying that there is
Station
instruction.
instructions from the principal secretary urban
She
housing.
is making
department
on behalf, she is the state
No,
council.
phone
Just
and we
very
put it
well.
out.
I accept her statement. Let her accept that this is not working right now. Let her accept. She will take instruction
Right,
on
Judge.
this. No, very. Judgment, upon the bench, please. I'll tell you what it is. This is what I'm talking about.
This is what
You say
Secretary
that I
of
do not know
Family.
what I'm talking about.
Absolutely, I have not seen it.
You can't be saying that what I mean, I don't know what he's talking
Mr.
about.
Panchal,
I'm sorry.
We don't
6:20.
everything.
No, you are snapping at me, madam.
I think all of us,
96 fourth Supreme Court cases.
all of us need a break for 2 minutes.
No, we don't, we can go until 5 o'clock. No break is required.
Certainly.
My lords are sitting in the vacation. That's what I'm saying. Paragraph 37. in the
Which 6:22,
96 4 SCC.
6:22.
Yes, but kindly come to paragraph 45 on page 645. 645.
6:45.
Yes, paragraph 37.
Before parting with this.
Yes, this is on the principle of accountability and there one more doesn't happen. Before parting with this case, we feel impelled to make a few observations. What happened in this case is illustrative of what is happening in our country on a fairly wide scale in diverse forms. Some persons in the upper strata, which means the rich and the influential class of the society, have made the into inverted commas property career the sole aim of their life. The means has become irrelevant. In a land where its greatest son born in this century said means are more important than the ends, a sense of bravado prevails. Everything can be managed. Every authority and every institution can be managed. All it takes is to tackle or manage it in an appropriate manner. They have developed an utter disregard for law. So, my lord, may quote this. The second judgment. Second judgment is 95 5 Supreme Court cases, page 762, paragraph. Paragraph 10 on page.
Again before parting.
Yes. That is the only thing we can. Spelling is I is missing, sir, in the party.
PRTING.
Yes, PRTY is missing.
No. The same is a different gathering on the unauthorized construction beyond.
Yeah. So this is important what I'm saying. The illegal is not taken care of in is fully in as much as the officers of the statutory body who had allowed the unauthorized construction to be made or make illegal what is important is this line, to take care of the injustice comes the officer who has misused this power is also to be properly punished. Otherwise, what happens is the officer who made the hay, when the sun shined, retains the hay, which tempts others to do the same. So I request that this may be considered, both of these. Now, my lords, as far as the Bombay Police Act is concerned, in this case, Rajkot case, my lord, I'm making a statement that permission was granted under the Bombay Police Act by the police authorities only to issue tickets under section 31X, but under 31W, permission has not been sought for and has not been granted.
31X of what?
Of the Bombay Police Act, 1951.
So what is 31W?
Yes, just, my lord, just give me a second. I'm sorry, Gujarat Police Act 1951.
Bombay is Gujarat.
Yes, now 31. Because permission was that you issue tickets for using and for doing other activities, permission has not been granted. X code.
Gujarat Police Act 31W.
31X.
Act.
Yes, I'm
Any
sorry.
police officer premises provided by the state government for his residence.
No, 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 this is not. What are the rules?
Anyway, sorry.
No, no, this may be.
Where is that?
I'll give. Next. 33.
Act.
Yes, 33, I'm sorry, I stand correct. Grateful to my understanding.
33.
Yes, section 33.
Police regulation.
Yes, I'm grateful to my understanding. Here, not to see X. Regulating.
And prohibiting sale of any tickets.
Now, I am instructed to say that
Where is W?
tickets, yeah, W is above, my lord.
Above
Yes.
licensing.
License.
That licenses are not.
Yes, this is not being cut.
That even Mr. Vir,
No, no, he is not saying for the police, sorry.
he is not there for the police. But she's saying that fire NOC means nothing.
Yes, yes, that I am also saying, and that's a lot, and that is what the judgment says.
It is ticketing license which is granted, not under 33W. That's a factually correct statement.
We'll assemble at 11:30 again.
Very well.
Yes, yes, for the order.
Yes, yes.
If it will permit us. 2 minutes break.
Only thing is, my letter when I just handed over, that instruction the corporation advocate may take.
What?
Is that it is going on, the gaming thing is going on. I just handed
It
over.
is going on. Let us see what, wait for some time.
No, he can, on phone he can get instruction.
Just see whether,
I've given him that copy.
2 minutes.
Not sure.
May I mention one thing, my lord, in this matter, SUO MOTO matter, my lord. My lord, my request as a, my lord, spirited person, my lord, that the demolition process should be stopped. Because, my lord, that evidence is gone, my lord.
That's what
And
Mr.
secondly-
Trivedi also
And
said.
secondly, my lord, the concept, my lord, constitution
Mr.
of
Trivedi has said that.
SIT. And thirdly, my lord, suspension is not a punishment to the officer concerned.
Correct, correct,
And till date, my lord, 5 to 6 SIT has been made by the government,
correct.
but no action has been taken, my lord.
The SUO MOTO
Only- Only
But,
one
my lord,
minute, sir.
earlier SIT also not resulted.
What happened, because there are reports that some are still missing. And if you.
Yes.
There are several people missing. What if you start excavating and taking away the debris?
No, no,
It should be stopped.
It has been removed.
No, it is not being
No.
done in this manner, but I will take instructions and.
Come back at
Not-
5 minutes.
Only a moment, sir. May I just conclude two things?
Yes, sir.
साढ़े 11 कर दो ना तेरे
Wait,
हिम्मत
no, no,
Amit bhai, I think you have disturbed me
Mr.
enough.
Trivedi.
I sorry, I withdraw my statement. Go ahead.
Yes, Mr.
Now,
Yes, Mr.
three things. Three things, sir. Three important things from what transpired by the learned additional advocate general, that they have stopped according to their own say. As rightly pointed out, that things are going on. I am not into that. Two things are very important. That wherever there is a fire safety permission, it has to be displayed in a very conspicuous place so that anybody visiting such zones with due permissions would know. Then they should put a map that where the emergency exists, where the other exits, that should be made known by way of a proper map at every place. In fact, we should take a lead that we should have such notices in our institution so that people can follow us. They may not come out and say that our institution, after passing the orders, is not following. Now, third important aspect which we read from the order, that preventive action. Sir, there are other PIs pending. Still, they are not being heard only because the accident has not taken place. In Surat airport matter, as other matters are pointed out, sir, I will just point out that we are waiting for the mishap to happen. That
Yes.
should stop in every such places. It should stop. We'll assemble in 11:30.
We'll come back for the order in 2 minutes.
Not
Yes, yes.
But as a party in person, I'm not allowed unless the court allows.
No, we are not allowing.
Lordship.
Please.
The order. The last submission that I made with regard to without the proper what my lord asked. My lord, the municipal commissioner of Rajkot Municipal Corporation, who has been at the top of affairs, helm of affairs, who is directly responsible for this event without there being any fire NOC, without there being any building response. Lord, I humbly request the Sound Court, action should be taken. What is the sense of taking action against two police officers, two RNB officers? It is an eyewash in my respectful submission. My lords may direct in this prerogative jurisdiction under Article 226 that commissioner should be suspended forthwith.
Forthwith.
There cannot be any laxity on that part. Small officers or lower rank officers, I'm not on them. But the person who is directly responsible has to be dealt with in accordance.
Like in Harani case, sir.
My lord, first,
State is defending.
no, nobody's but two submissions, my lord, Mr. Trivedi submitted that let all fire NOCs be displayed outside. No difficulty, that can be done. That is a long-term measure which it is in the interest of all concerned, that's all. Second submission was that an endeavor is being made, to remove all evidence. The FSL team has visited twice over. All photographs have been taken. All evidence has been collected. It is the fire, it is not the police authorities which is removing anything. Fire authorities, for the purpose of recovering bodies, to our knowledge, there are still 4 bodies which are missing. For that purpose, it is the fire authorities which are taking this action. Police authorities are not doing. There's no tampering with it.
Yes, Mr. Bill, why should the municipal commissioner not be held accountable for not complying with these orders for the last 4 years? Blatant under the nose of this municipal commissioner, admittedly by the state now, that the gaming zone is running for 18 months. Somebody has to be held accountable. No?
This commissioner has come only recently. But
Come only
not
recently
had-
or what? We are not concerned with whoever has come recently.
No commissioner or.
Every time this will happen, that something happens, sixth mishap in line, if you see. Sixth mishap in line.
Most unfortunate.
Yes.
But most unfortunate, unpardonable, no defense.
Then-
No defense. No officer would allow this to happen.
Recent
This is
commissioner,
not, this is
somebody
not
has to be held
an,
answerable, no?
this is not an, the commissioner is.
Charity
taking-
begins at home.
The commissioner is taking this issue with utmost seriousness.
I'm sure, we are
He has,
advised that
he
he
has
is bound to
not
do it.
left the site for the last 48 hours.
What was he doing for the last 18 months when this gaming zone was running?
Lordship, this
Without a fire
application
and
has come to the estate department. The moment it has
No.
come, steps have been taken. Lordships will
Mr.
only allow us
Consul,
some time to file our.
It's
reply.
256. The accountability has already been decided by this Honourable Court.
That.
256. Well, not easy defending the commissioner
Civil application.
for this action. On one side, he's saying it's unfortunate.
Mr. Pancha.
No, it is not fair.
Just allow us to make our.
Yeah, please make the submissions. What stand clear after killing 33 people, 28 people? What stand clear?
Most unfortunate.
Just one more factor. Not 6, but as I address the Honourable Court, 7 officers are suspended, the 7th being from the fire department. Because the fire department is equally responsible for observing, monitoring.
Civil application, so it's a civil application, we pass a common email. Application PIL number 5, civil
34.
application 1 of 2024. In PIL so and so with PIL number 7. 34. So, we have in our order dated 26th of May 2024. Expressed our anguish at the event that occurred at Rajkot. The bench was constituted yesterday pursuant to the orders of the Honorable the Chief Justice. The SUO MOTO PIL was registered And so was the civil application in WP PIL 118 of 2020 circulated for hearing. The hearing was adjourned for today. The state of Gujarat in both these proceedings learned additional advocate generals respectively, that is Miss Tanisha Kumar and Mr. Mitesh Amit, who appeared with the assistance of
Mr. Krutik Parikh.
Mr. Krutik Parikh, learned assistant government leader,
And
and
And Miss Hetal Patel.
Miss
Hetal Patel.
Hetal Patel, assistant government leader.
Assistant Governor.
Assistant government leader. So, for the Rajkot Municipal Corporation, the Ahmedabad Municipal Corporation, and the Vadodara Municipal Corporation, respectively, Mr. G.H. VIRK has appeared. So, Mr. IPL Shena Pandya ka hai tam?
Kaushal Pandya.
Kaushal Pandya. I was saying Hardik Pandya. Mr. Kaushal Pandya has appeared for the Surat Municipal Corporation.
Lord May, my colleagues, Devnani.
Huge. We have heard Mr. Dharmesh Devnani in the SUO MOTO PIL. From Mr. Vijesh Trivedi. So in the civil application, we have extensively heard Mr. Amit Panchal, who has appeared as party in person. Amendment granted in civil application 1 of 2024 and leave to amend in WPIL 34 of 20.
One.
There are 10.
Yes.
Mr. Amit Panchal, to an amendment based on record, newspaper cuttings reporting the unfortunate incident at Rajkot. Taking us through the comprehensive general development control regulations 2017 into bracket CGDCR for short. I would submit that by the notification dated 3/10/2019, the government of Gujarat made certain variations. Mr. Panchal, kindly listen to what we have said. So, unless and until subject to, we may
No, my lord, I'll listen. I'm sorry.
Because we may make some mistakes in what your submission. Made variations. The CGDCR. These variations were made in exercise of powers under various acts such as the Gujarat Town Planning and Urban Development Act 1976. The Gujarat Municipalities Act, 1963, etc. Would invite our attention to Regulation 3.1. Regulation 3, which deals with development permission, building use permission. Reading Regulation 3.1. He would submit that. That in case any development in any building or in or over any land is to be carried out, it has to be made only after making an application in writing to the competent authority. In other words, in his submission, the TRP gaming zone at Rajkot, which was located at a 3,000 square meter plot, was without any permission, which was a prerequisite. No application was made for such permission. He would invite our attention to Schedule 10, which provides a checklist of building specification which need to be verified by the competent authority before issuing of a building use permission. So according to him, apart from verification as to whether there is enough parking space, there need to be signboards indicating the entrance, exit, and location of parking spaces. Emphasis was laid to the fact that proper arrangements are made for regular maintenance of fire protection services as provided in the National Building Code and in these regulations. So before occupying a premises, comma, an occupancy certificate to be issued by the concerned designated authority after inspection of the building. It should include verification and compliance of necessary requirements for the fire protection under the provisions of the Gujarat Fire Prevention and Life Safety Measures Act, 2013, and rules and regulations made thereunder. Inviting our attention to Schedule 11, he would submit that the buildings would require fire protection consultants. So admittedly for the game zone in question where the unfortunate incident occurred, neither was there any occupancy certificate or an application made for such certificate.
There was fire NOC applied
No, that we have said in the earlier.
occupancy and
Neither was a fire occupancy certificate applied for. Inviting our attention to regulation 5.1.3, which is dealing with the procedure during construction. Would submit that the competent authority was bound to inspect such undergoing construction for fire safety and protection. Part 2 of the regulations were placed into service. Relying on table 6.3 regarding use permitted in each category. Would submit that category into inverted commas mercantile -2. That within its classification shopping malls, etc., but not gaming zones. So part 3, the regulations were also pressed into service. Which dealt with regulation 14, which provided for fire prevention and safety. In sum and substance, according to Mr. Amit Panchal, reading the regulations would indicate that the sine qua non of the entire procedural gamut was the requisite fire NOC which was required for a gaming zone to be set up. Stop. Nothing on record there is, or it is an admitted fact that there is non-compliance of the GDCR, the regulations and provisions under the Gujarat Fire Safety,
Fire Prevention and Life Safety Measures Act.
Gujarat Fire Prevention and Life Safety Measures Act 2013
Rules.
and rules thereunder. The provisions of the act have not been complied in any manner. Reliance was also placed on section 253 of the Gujarat Provincial Municipal Corporation Act 1949. Submit that any person who intends to erect a building has to give a notice of such intention in the prescribed form, which admittedly was not done in the facts of the case. Good stop. He would take us.
બધું we pack कर दो भाई. It is item we pack everything. કશું ભૂલતું નહીં. આજે ને પછી છેલ્લે નહીં.
You can tell him to mute the mic.
You can mute it.
Me खाली कही दो. Somebody can tell him. And the prayers made that therein to submit that the applicant has been constrained to move this court in the pending PIL of the year 2020. That a report can be called for with regard to the fire incident. From an explanation be called for from the state as well as the Rajkot Municipal Corporation from other appropriate directions be issued against persons accountable, including the officers of the Rajkot Municipal Corporation. And such compensation and penalty be recovered from the appropriate erring persons. Mr. Banchal would invite our attention to the orders passed by this court in the pending PIL from time to time. Inviting our attention to the order dated 26/2/2021. From where a reference is made to the extensive order passed on 15/12/2020 We would invite our attention to the order of the date. That is 15/12/2020 passed by this court. The PIL concerning fire safety measures. Relevant portions of the order were read. Essentially paragraphs 23, which indicate that directions have been issued by this court to ensure that the fire prevention and life safety measures are taken by the state of Gujarat, including in buildings which are temporary structures. We would also press into service the directions which the court had issued, directing the respondents to strictly act in conformity with the provisions of the Fire Prevention Act. So we would also invite our attention to para 24 of the order, which deals with the fixing of accountability of the officials of the relevant authorities. And submit that a serious view needs to be taken in this case by fixing the accountability of the municipal commissioners of the respective municipal commissioners, the respective municipalities, especially that of the Rajkot Corporation, for having blatantly violated the directions of this court in the pending PIL. We will also invite our attention to the order of the Supreme Court dated 27th of August 2021. Wherein, the Supreme Court had categorically observed that there can be no condoning of the gross irregularities in constructing buildings which do not have building use, which has resulted in the violation of law, including the incidents of fire, which of the state of Gujarat was directed to take proactive steps. So we would then take us to the orders. The PIL passed thereafter. There too. 4/4/2022. Rajkot Corporation had filed an affidavit ensuring compliance of fire safety measures. And the court in the order had observed that the corporations will take necessary steps with all seriousness in in light of the fire incident that occurred on 28/11/2021. So there can be no power or the authority to condone the deficiencies under the various provisions of the Act. And there can be no regularization in absence of fire safety measures. The SUO MOTO PIL file, PIL, Mr. Brijesh Trivedi would submit that over a period of past 24 hours, JCB machines have been deployed at the site for removing evidence from the site. And therefore, there is a concerted effort by the authorities to remove evidence. So after the visit of the Chief Minister, FIRs have been lodged at 3 a.m. Clearly, eyewash. Full stop. Families are still struggling to overcome their grief. There are families who have still not found their missing KIN kin. So 2 sets of employees need to be held accountable. One which were responsible for the initial setting up of such facilities such as gaming zones. And the other which fostered and continued to turn a blind eye to such gaming zones which continued to operate for a period of over 18 months. Under the very eyes of the officers of the municipal corporation. People need to be held accountable. And all game zones all over the state need to be shut down, which do not have such requisite permissions under the various statutory laws. Mr. G. H. Virk has appeared for the Rajkot, the Vadodara and the Ahmedabad municipal corporations respective, and placed a short note on record. Short note on record. With regard to the note, in context of the Rajkot Municipal Corporation, he would submit that the land over which the TRP game zone was developed submitted an application showing particulars of unauthorized construction. Stop. An application was made on 22/4/2024.
Fourth day.
Fourth May.
Fourth, on
Routine if you.
okay, sorry,
I'm sorry.
4th May 2024. Under the Gujarat Regularization of Unauthorized Development Act, 2022. Which of the nature of construction was fabricated steel frame structure with boundary of steel patras in all ground plus one floor. Establishment has been operating since June-July 2021 as per the permission granted by the city police. On 9th May 2024, the Rajkot Municipal Corporation addressed a letter to the owners of the game zone, asking for certain clarifications which included providing for necessary drawings, fire NOC, structural stability certificate, etc. Till such time, the corporation was unaware of the existence of the game zone. As no permissions were applied for. Full stop. Paragraph. By a separate note, Mr. Virk has placed the particulars of gaming zones within the jurisdiction of the Ahmedabad, Vadodara and the Rajkot Municipal Corporation. Perusal of the list in his submission would indicate that as far as Ahmedabad and Baroda are concerned, requisite permissions are in place for almost all the gaming zones, except one, namely all gaming zones. Full stop. As far as the Rajkot Municipal Corporation is concerned, of the 11 gaming zones, only 3 gaming zones have building use permission. Full stop. In other words, within the territorial limits of the corporation, 8 gaming zones were without fire NOC and or BUC. That means at least 3 have no BU permission.
I'm sorry.
3 have no BU.
No, your lordship, more than three would not have been permission. For
More than-
example, can I give one example? Lordships may have page 8 of my note.
Huh.
Lordship is looking at items 6,
6, 7 and 9,
9 and 10. All four have fire NOC,
but no BU.
3 have BU. 10 does not require BU because this is in open air.
Of the 11, game zones, 3 game zones have BU permission.
Lordship.
And the other 3 have even the fire permission. Fire NOCs,
Lordship. 4 have fire.
4 fire NOCs.
Also BU. Also BU. Also
Also, and 4 are fire NOCs as well as BU.
for 10, there would be no requirement of BU because it would be an open air area.
Of the 11, 3 have the requisite BU permission, and for one of them, no BU permission is
How
required.
will it be a temporary construction or structure in an open would also require BU?
As it is an open question. This is submission.
Wait,
Full stop. You would submit that initially, comma, the TRP zone owners had started their operation by only holding a, by having a go-karting area on the ground. It was only in June 2021 that the ground plus 1 and the second floor was constructed. Mr. Kun. Vishal Pandya. Mr. Vishal Pandya appeared for the Surat Municipal Corporation and would submit that all the 12 game zones situated in the city of Surat have the requisite fire NOC. Full stop. Although there are some lacunas in certain game zones, which are 10 in number. Such as no fire system alarm being installed. Requisite action is being taken. So we would submit that. The corporation would not be in a position to verify where the antecedents or the operational features of the building once an owner occupies for a particular classified permission, either for residential purposes or non-residential purposes, and subsequently converts it into a game zone. The corporation would be unaware of such conversions. It is the duty of the person who runs such game zones to come forth and apply for the requisite permissions such as fire NOC, police permissions, and for requisite permission under the for the electricity purposes through the DGVCL. unless and until renewal is carried out for fire safety every 2 years, the corporation would be unaware of these modalities. Ms. Manisha Lavkumar, learned Additional Advocate General for the state. Submitted, candidly, that this was not an adversarial litigation. And the state has acted and is committed to do so on the issue with utmost seriousness. Immediate measures have been taken in as much as all gaming zones have been sealed. Stop, it is not a knee-jerk reaction. And an assurance has come forth from the state that no one will be spared. As many as 7 officers have been suspended.
I can give the details if the Honourable Court, so I'll give it on a page.
Which he will put it by way of a separate affidavit. So she would submit that pursuant to the fire call, the help will immediately within 5 minutes reach the site. An FIR has been filed. And the owner of the gaming zone, Mr. Gujarat, has been arrested. So has the manager been arrested. Steps are being taken to see that the remaining owners of the game zone are arrested and a lookout notice has been issued. The FSL has rushed into the spot immediately. CCTV footage has, through the DVRs, has been recovered and is being investigated. So prima facie count of fire. The cause of fire was sparks that flew from the welding unit. And there were foams which were inflammable material, which resulted in the fire. She would also place on record notifications of the state two in number of 25/5/24, by which the state has constituted a special investigation team headed by the Additional Director General CID Crime and consists of senior officers of the state government. Submit that the terms of reference to the special investigation team are the same which are the questions which have been posed by this court in its order of 26/5/2024. In as much as the team would look into the circumstances under which the fire occurred, whether the gaming zone had an approval, and even apart from these gaming zones in the corporation limits, by a separate notification, all the district magistrates, the commissioners of the corporations and municipalities, the police commissioners across the state have been informed. Undertake this exercise on the same lines. You would also rely on a notification from the state.
Would my also please to mention that immediate report is sought for in 72 hours?
Sorry, yeah, that is, immediate report has been sought for. And the report of the special investigation team shall be ready either by today or tomorrow,
In 72 hours, we've asked for
which
it.
has, which is,
Then a detailed report after 10 days.
an immediate report is sought for. And therefore, within 72 hours, an interim report shall be furnished, subject to a final report being filed in the next 10 days. She would also place reliance on February 2024 notification which, pursuant to the directions of this court in the PIL concerning the Hermit boat tragedy. At the 5th high-level meeting, certain key points have been discussed, and the draft rules are in the process of being framed.
Draft rules are framed.
The draft rules are framed, which include rules relating to amusement parks. And therefore, the issue which relates to the present PIL shall be taken care of. Mr. Laukumar submits that there can be no dispute on the fact that the officers of the corporation need to conduct regular supervision with regard to the fire NOCs. It is a sine qua non for in your view permission. Which you would rely on Regulation 2.109, which defines temporary structures and would therefore submit that these game zones can certainly not be categorized as temporary structures so as to overcome any stringent requirements which need to be undertaken under the CGBCR. of the operators having applied for regularization for 3 years, after 3 years, cannot be an application which can be considered. So Mr. Pancha in rejoinder to rely on two decisions of the Supreme Court on the question of public accountability. Relying on the decision in the case of '96. Relying on the decision in the case of Delhi Development Authority versus Skipper Construction. CO into bracket P bracket over limited and another reported in 1996 for SCC 622. Press into service paragraph 37 of the decision. Full stop. Reliance was also placed on decision of the Supreme Court in the case of Dr. G. Full stop N. Full stop Khajuria AHAJ and others versus Delhi Development Authority and others. Reported in 1995 by SCC 762. Para 10 was placed in this.
That was one aspect. As far as the fire site was concerned, there was a large quantity of petrol and diesel used for go-karting or other purposes. And now, Lord, after the fire, that would not be there. So that, of course,
But my lord, that FSL report will
Madam,
indicate.
Madam,
I had a word
Madam,
with-
let me complete. So that would come out in, I'm being
So
extra polite,
it's-
and my learned friend will appreciate that. I'm saying that will come out in the report, the FSL report on.
What is-
But
Is
that-
missing in the FIR.
That, my lord, that
Right.
is the submission. It will
Right.
come out in the FSL.
It is missing in the FIR, sir. The huge quantity is against the Petroleum Act, wherein it is mandatory to seek such license for storing such huge quantity of petrol and diesel for any purpose.
Mr. Panchal would also rely on the provisions of the Gujarat Police Act. Section 32 of the Gujarat Police Act and submit that. What was obtained was a permission under section 36, 33 into bracket small x and not one under section 33 small w of the act. Correct. Having considered the submission,
One, my learned friend, Mr. Devnani, my notes are not read.
No, my submissions have come. Almost all submissions have come.
consent for the
I'll adopt this.
SUO MOTO petition. Would invite the court's attention to the various newspaper cuttings Submitted, he would appreciate that. They need to be taken immediate, in fact, your submission. Sorry, immediate steps need to be undertaken. So,
Immediate steps.
so these steps should be in the nature of a preventive as well as corrective steps. The court needs to inquire as to whether permissions required under the relevant provisions have been granted. And if no such permissions were granted, what action the state has taken. Full stop. We would also rely on the orders passed by this court on the question of accountability. Paragraph. While entertaining SUO MOTO proceeding pursuant to our order of yesterday, he had done so pursuant to several newspaper reports which had come to our notice. Unfortunate for the state, there has been, as reported in one of the newspapers, a trail of tragedies. May 24, 2019, fire engulfed the Takshashila Arcade, Surat, causing death of nearly 22 students. August 8, 2020. 8 patients suffering from COVID-19 lost their lives at Shreya Hospital, Ahmedabad. January 7, 2023. 17-year-old girl was killed after a fire broke out at the Shahi Bagh apartment, Ahmedabad. July 30, 2023. A short circuit caused a major fire at the basement of the Rajasthan hospital. Fortunately, no casualties were reported.
Bharuch fire of 20.
8 minutes. Rajasthan. October 30, 2022. Bhuto Pul at Morbi collapsed. 135 people died.
Just 1 minute. 1st May 2021, 16 persons died in Bharuch.
We are just referring to what is.
Oh, otherwise, this is one of the 16 persons died.
Complete the link breaks. Then happened the Harni Lake tragedy at Vadodara. There as many as 12 students and 2 teachers lost their lives. So this possibly is the 7th tragedy in line where we still do not have a body count, as several family members of the tragedy that occurred on 25th are missing. As recorded in our order, we have now been taken through the visions of CGDCR. Apparently, reading the provisions would indicate that whenever any occupant of any land or any person has to carry out any development, a development permission is required. So a procedure is envisaged under the provisions to obtain a building use permission. During the procedure, during the period of construction, there has to be a periodical inspection with regard to fire safety and protection of building under construction, as envisaged under Regulation 5. A checklist is provided for in Schedule 10, which includes verification whether there are proper arrangements made for fire protection services as provided under the National Building Code. Stop. There has to be signages. There have to be signages indicating entrance and exit. Under the provisions of the GPMC Act, Section 253 provides for a notice before construction. Stop. The term building is defined in Regulation 2.12 of the CGDCR. Which means buildings about permanent, which means all types of permanent buildings, but structures of temporary nature like tents, hutments, as well as shamiyanas erected for temporary purposes are not included. Temporary structure is defined in Regulation 2.109 to mean a structure erected for temporary purposes or ceremonial occasions. Even the GPMC Act defines the term building in Section 2 into bracket 5, which includes a house, outhouse, shed, etc., and other enclosures of structures. From the submissions made by the Learned Counsel for the Rajkot Municipal Corporation and the notes filed before us, would indicate blatant inaction on the part of the authorities of the Rajkot Municipal Corporation and without mincing words, we prima facie would observe that. But for the connivance of the authorities within the corporation, including its officers, from the police department, and the authorities of the roads and buildings department at the local level, gaming zone where the tragedy occurred could not have flourished under the very eyes of the police authorities and the Rajkot Municipal Corporation. On the note submitted by the Council for the Rajkot Municipal Corporation, it is apparent is that the TRP game zone was developed in June 2021. So it was only 4 years thereafter, approximately 3 years thereafter, that the owners applied on 22/4/2024 under the provisions of the Gruda Act for regularization. What was constructed was a fabricated steel frame structure with the boundary of steel patras. Apparently, it is the stand of the corporation that the permission was granted by the city police. It has now admittedly come on record by virtue of an application made by the owners on 9/5/2024. And the queries set forth by the corporation by the letter of 9/5/2024 that the game zone had no fire NOC, no structural stability certificate. They were asked to produce the same in order to get the benefit of regularization. Paragraph. The indication is good. And the legal monitor of the corporation. Both the learned counsel, the party person, Mr. Amit Panchal, as well as the state counsel, namely Ms. Manisha Lavkumar, the additional advocate general, has brought to our notice provisions of Section 8 of the Gujarat of the Gruda Act. Reading subsection 3 of Section 8 would indicate that an unauthorized development shall not be regularized if it is inconsistent with the provisions of Gujarat Fire Prevention and Life Safety Measures Act, 2013. The facts itself are eloquent, therefore, to indicate that game zone at Rajkot was conceptualized, set up, and continued to operate under the very nose of the corporation's officials without the requisite permissions. Of the structure certainly cannot be branded as a temporary structure into inverted commas, as we have seen the definitions of the term into inverted commas building and into inverted commas temporary structure, which means to include shamiyanas for ceremonial purposes. A gaming zone flourished for approximately 3 years without the necessary permissions, purportedly under the guise of a temporary structure, prima facie, by obtaining permission only under the provisions of section 33 into bracket small x, the Gujarat Police Act, whereas, it did also require a permission under the provisions of section 33 into bracket W, which deals with licensing or controlling places of public amusement or entertainment, regulating the means of entrance and exit at places of public amusement, and providing for the maintenance of public safety. It is not in dispute that sans the fire NOC, judicial notice can be taken of the fact that such a game zone could operate within the vicinity of a local police station without such a permission, for which even the police department has a lot to answer. Coming to the stand of the state government, as far as the other corporations are concerned, that is the Ahmedabad Municipal Corporation, the Vadodara Municipal Corporation, and the Surat Municipal Corporation. Prima facie, in substance, there appear to be some compliance as far as the fire NOC, etc. is concerned. Albeit in a typical knee-jerk reaction, the authorities of these corporations have swung into action and noticed the deficiencies in the gaming zones, the list of which have been furnished to us, only after the tragedy that has occurred at Rajkot. These corporations may have acted as a result of the trigger that occurred at Rajkot. That may be an eye opener, but it is most unfortunate that it is only the death of innocent children and the young ones have opened the eyes of the authorities at a stage when the families of Rajkot have lost their loved ones. The state of Gujarat, as usual, in its immediate response, has appointed a special investigation team, SIT, by its notification dated 25th of May 2024. And we are conscious of the fact that the terms of reference that have been set out in the notification are somewhat identical and similar to the issues that we have raised in the SUO MOTO PIL. We are told that an interim report shall be furnished in a day or two of the committee, which promptly has been asked to do so within 72 hours of the incident. What we have narrated here above would indicate that of the trail of tragedies that we have referred to, the villain which has snuffed out innocent lives of the citizens of this state are the fire incidents which have occurred. Most of them appear to be so. We need not repeat the past incidents that have occurred as a result of the blatant breach of fire safety norms, which resulted in filing of a PIL before this court. In the order dated 15/12/2020 passed by this court, while taking on record the affidavits filed by the state of Gujarat and the respective corporations, it will be ironical to record the sentiments of this court when it observes that, into inverted commas, it would be too much, comma, or rather, comma, it would amount to adding insult to injury to tell the kith and kin of all the victims who perished in different accidents of fire that take solace from the fact that the state government has appointed a commission of inquiry into inverted commas. Paragraph, we may add that we have no qualms on the fact that the state government in the present case has invited a special investigation team but the question that begs to be answered is, will that sufficiently assuage the sentiments of the families who have repeatedly lost their kith and kin on these tragedies which have obviously been man-made? This court in paragraph 23 of the order of 15/12/2020 issued certain directions. To forthwith ensure that fire prevention and life safety measures are taken and implemented forthwith in all buildings of the state of Gujarat, as required under the CGDCR 2017. Stop. The respondents, which are the present, were directed to ensure that effective steps are taken forthwith. The fire prevention and safety and for the protection of the life and property of citizens in various types of buildings, including temporary structures, so as to serve the object and purpose of the Gujarat Fire Prevention and Life Safety Measures Act 2013. The court further went on to fix accountability of officers and reading para 24 of the order would indicate that the accountability for illegal action or inaction by the authority, in the hierarchical setup of a corporation rested with the municipal commissioner. The court had quoted the observations of the Supreme Court, which had done so almost 2 decades earlier, as so quoted by the division bench. So we have also read the order of the Supreme Court dated 27th of August 2021, which observes that condoning the gross irregularities in constructing buildings which do not have building use, or as the case may be, fire permissions, has resulted in violation of the law to the detriment of public health. The Supreme Court observed that the state of Gujarat shall take proactive steps to ensure that the rule of law is observed. The state of Gujarat shall take proactive steps to ensure that the rule of law is observed. public accountability paragraph has been set out in the decisions of the Supreme Court referred to here and above and relied upon by Mr. Amit Panchal. There are 10 of the decision in the case of N. Khajuria Supra reads as under. The chronology that has unfolded above admittedly indicates that yes, the state has acted with promptness, and maybe that the reference is that the terms of reference of the SIT capital are the same as the ones raised by us, and its report, interim report, is awaited. We have no qualms in waiting for the report, which the state will place with the requisite submissions which have been made during the course of today by way of an affidavit. What is apparent from the stand of the councils, respectively of the corporations, especially made on behalf of the Rajkot Municipal Corporation, is that the game zone at Rajkot was conceptualized by the owners in 2021 and continued to operate till the 25th of May 2024 for over a period of 3 years, admittedly without a fire NOC or any requisite permissions required under the statutes, respectively. The audacity of the corporation is apparent in as much as the corporation on 9th of May 2024 writes to the owners to furnish fire NOC. The question that begs to be answered is, the inaction of the authorities in even inspecting the site in light of the regulations to consider whether a so-called game zone existed and flourished at the cost of the lives of the children we lost. Adding insult to injury was the non-compliance of the directions which have been issued by this court from time to time in the fire safety PIL. Non-compliance of such directions tantamount to contempt of the court. So we do not at this stage intend to get into that question and leave it open at a later stage in this very litigation. In the question of accountability, It is very easy for the council for the corporation, that is the Rajkot Municipal Corporation, to say that the municipal commissioner, the incumbent is a fresh entrant on the office. Stop. On the question of accountability, we are of the opinion that from the time when the game zone was set up in July 2021 till the date of the incident, the respective municipal commissioners who held office at the relevant point of time should be held accountable for the tragedy that occurred.